Everybody. Good morning. If we can please come to order. Welcome to the Senate Judiciary Committee, our last meeting of this session. Everybody's very excited this morning. It'll be daylight when we leave. Make sure y'all text Jesse Stone and let him know when you leave today. It's still daylight, hopefully. One way or another. Yeah, tomorrow. It will not be daylight tomorrow. I'm going to ask Senator Kirkpatrick if you'd like to open us up in a word of prayer.
Please join me in prayer. Dear Heavenly Father, the days are long and the time is short, and we thank you for giving us another day to work on the people's business, and we're asking you for energy and calm and strength to get through the next few days. In your holy name, amen.
Thank you. So we are going to bounce around a little bit on the agenda and our order today. And so I will give the committee members time to find the bill in your folder. We're going to start with House Bill 383. Representative Carson, you want to come up to the podium and give us 1 second. All right, we're working off of a substitute, which is LC 441736 ERS. Is that what you have?
Yes, sir. Yes.
All right, the floor is yours.
Thank you, Mr. Chairman, members of the committee. Appreciate being here. House Bill 383 was brought to us by our friends in the American Jewish Committee and several other Jewish-related organizations. This is an update to the anti-BDS statute, BDS being boycott, divestment, and sanctions against the state of Israel. And what we're doing is updating this language. Previously, it basically said that anybody who participates or endorses the BDS movement, again, boycott, divestment, and sanctions against Israel, we as a state are not going to contract with them. The overall intent was to not have the state enter into contracts that would be with corporations that endorse the BDS movement, but also from an economic standpoint, not limit the state in regard to our potential sourcing of contracts with the state of Israel. So what we're doing here is we're limiting the scope. And I know that sounds odd to have this endorsed by the American Jewish Committee, but we're limiting and refining the scope to be the original intent to be applicable essentially to corporations, Mr. Chairman and committee, essentially corporations, but we're really talking about medium and large size companies and contracts with the state that are worth $100,000 or more. You see that on line 31. And the reason we chose 100,000 is because, as you know, and the committee knows, Mr. Chairman, 100,000 is the minimum amount per Title 50 that is required for a state contract to go out to bid. So that's essentially what we're doing. I think I sent around a letter of support or a letter of description about the legislation from the American Jewish Committee. That's really what the bill does. It allows free speech by individuals and sole proprietorships. But what we're basically doing is taking a step back and refocusing this statute at the request of the Jewish community to say we're not going to have state contracting with entities that are engaged in basically the entities that are against the state of Israel and the nation of Israel. So we're just updating the statute.
One question I have for you on line 34 of your bill. While you took out an individual on lines 31 and 32, you still have such individual or on line 34. Is that just another place we need to do a cleanup on the sub?
That's a place we need to clean up. Yes, I apologize for that.
All right, at the appropriate time, I'll ask a committee member to bring that amendment to strike individual or on line 34. Any questions from the committee? Okay, let's get a motion on the bill first. What's the pleasure of the committee? We have a motion to pass by committee substitute by Chairman Tillery. Is there a second? Second by Senator Kennedy. Any amendments, Senator Kirkpatrick?
Yes, I'd like to amend line 34 to delete to delete individual or. So it would read, such company is not currently engaged in.
All right, I'll take that as a motion. Is there a second? We have a second by Senator Kennedy. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. Passed unanimously. Now back to the underlying motion. Any discussion? All those in favor of the motion, please raise your hand. Any opposed? It passed unanimously.
Thank you, Mr. Chairman.
Who's going to carry the bill in the Senate?
My doctor, Dr. Kirkpatrick.
All right. Thank you so much. The next bill we're going to take up is House Bill 411. Representative Gullett. Come on up and give us just a second to find the bill in our folders. All right, good morning.
Good morning.
See, we have a committee substitute 413119S.
That's right.
All right, the floor is yours.
Thank you. So this bill creates a prosecuting attorney's oversight commission. If you pull out your Georgia Constitution, you'll see in Article 6, Section 8, Paragraph 2, discipline, removal, and involuntary retirement of district attorneys. And it says any district attorney may be disciplined, removed, or involuntarily retired by as provided by general law. So that's the basis of what we're trying to do here. It creates a commission similar to JQC, but for elected district attorneys and elected solicitor generals. Commission is made up of 5-member investigative panel and a 3-member hearing panel. Investigative panel is responsible for the investigation, prosecutorial, and administrative functions of the commission, which is line 139. Hearing panel is responsible for adjudicating formal charges filed by the investigative panel, issuing disciplinary and incapacity orders, and issuing standards of the commission. The commission will start April 1st, 2022, and will start writing the standards of conduct and rules for the commission's governance. And it gives the commission until April 1st, 2023 to promulgate rules and have specified that no complaint shall be filed before July 1st, 2023. This is line 137. This is to give the Supreme Court time to review and adopt the rules. Section H, which is line 142, is related to the totality of behavior for a district attorney or elected solicitor general. And if there's a complaint, we have required a sworn affidavit to be submitted detailing the personal knowledge of the facts supporting the complaint, which is line 159. Section I, which is line 157, is specific to courtroom behavior and what type of complaints the commission may not entertain unless the complainant can show it plausible that the behavior was based on 6 factors, which are line 170. And I want to say that this bill is not an attack on the ability of district attorneys, solicitor generals to make decisions on individual cases. It's not an attack on prosecutorial discretion. All we're doing is addressing willful misconduct like sexual harassment, like the misuse of funds, like the persistent and blanket refusal to prosecute charges based on politicized motivations. The bar and the Supreme Court have a very important role to play in this, and this bill recognizes that. As someone who has a community that's gone through a district attorney problem, it tears your community apart. And your constituents, when they have a disdain for the justice system and for the office holder, you just realize how badly this is needed. I'm happy to answer any questions throughout the bill, but I want to talk to the sub real fast. The sub changed one line, or it was in one line, and it changed judge to district attorney or solicitor general just because it was a carryover for the actual root of what we created. It was initially started with the JQC, and so it was we modeled it really after that, and that was just a carryover mistake.
I have One question. Why can the state bar not handle this instead of having a new commission deal with this issue?
Sure. They Rule 3.8, which we call out in the one of the rules, actually recognizes that the state bar has a role to play. I think unfortunately the state bar hasn't played that role, and I'm not sure that maybe they can, but I don't think that they have, and I think we have the ability to through the Constitution. And so this really, they could have played the role in the JQC as well. They oversee judges as well, and we created a commission to oversee them. So this is really no different than that. So we do recognize the role of the state bar, but I think this is a role of the legislature to create this commission.
And another question, speaking of the JQC, with the JQC, the Senate actually has the authority and the requirement that we confirm the members of the JQC, but that's not in this bill. Is there any reason the Senate wasn't given the confirmation right?
No, I think just when we came up with the with this investigative panel, it was just a little different makeup specific to what we thought was right for district attorneys and solicitor generals, not judges. So you guys do have a pretty good appointment role there. You have on the Senate side, you have the LG appointing an attorney with prosecutorial experience. On the investigative side, you also have one attorney with prosecutorial experience appointed by the Senate Committee on Assignments. That's line 58 and 69. And then for the hearing panel, you actually elect as a full Senate the district attorney that would be serving on the hearing panel, and that district attorney is actually the chair of the hearing panel. So I think the Senate has a very substantive role here with the commission.
Any questions for the author of the bill? All right, thank you. We have several people signed to speak.
All right.
We will start with Pam Bettis, a Solicitor General in Henry County. There she is. Good morning.
Good morning.
How are you?
Good. How are you guys?
Good.
I'm glad the rain held off a little bit so we could get in. Thank you for this opportunity to speak before you today, and I absolutely understand Legislator Gullett's position on this bill, and it's frankly disgusting and
This is my fault. I turned your mic up. If you'll get just a little bit
Okay.
closer to the mic, and then I won't have to turn it up.
it's disgusting and embarrassing that you or anyone would have to be put in a position to have to deal with an elected official, particularly a district attorney, a solicitor general, a judge, in a position that just doesn't seem to be able to lead from a place of humility and honor. Their first dedication should be to the citizens and to our law, and to act in the manner that some of them have acted is, like I said, embarrassing. The concern with this bill, it's not that we don't think that these individuals should be dealt with and dealt with swiftly, is that, discretion is a core of prosecution. And when you're in an elected position, you have constituents that vary across the state. As I spoke yesterday, and there were several people in the room, and I talked about how below Twiggs and above Valdosta, there's not any traffic lights. So one section of that bill was really not needed, and that was in a joking manner. But the constituents are so different across the state. And when you're in these positions as a prosecutor, you have to listen to your constituents and listen to the crime that is, in their community and what they feel should be your primary focus when you're prosecuting the cases. We are so fortunate in Henry to have had leaders that put in things like pretrial intervention and accountability courts and things of that nature. So one of the biggest worries we have over this bill is that in some way the discretion that we've had to hone and carve out and utilize over the years that comes from experience and exposure could be judged in a manner that from others in the community, from their constituent base, that's not the same as our constituent base. More importantly, the legislator has the power to impeach these individuals. And honestly, you shouldn't be put in that position. And it's unfortunate that Mr. Gullett, Legislator Gullett, has been put in this position. It is a stain and an embarrassment. So, you know, but you have that power. And I hate that you would be in a position to have to use it, but that's something that should be done and not be ashamed of. Because you're leading and saying that, you know, you were put in place by the voters to serve in a capacity and you failed to do so. So I simply ask that there be some consideration. We be allowed at the table, if you would, if you have time, for us to talk and hone any type of rule. We've worked diligently. Ms. Boston, I think, will speak as well. D.A. Boston, who is extremely eloquent, has worked for over a year now with the bar to hone 3.8. So we just simply asked for consideration that there are issues with this bill, and we worry about particularly a section toward the end where we would have to be recused from cases if there were a complaint filed. And we foresee in my jurisdiction, where we handle hundreds of DUIs, one predominant DUI attorney who doesn't like the fact that I'm not reducing them without good cause to reckless driving may then have someone file a complaint, recuse me, and have another prosecutor come in that may do that. And so that's a worry as well. So thank you very much.
Any questions for Ms. Bettis? All right, thank you. Next, we have Sherry Boston, the District Attorney for DeKalb County.
Good morning. Thank you so much, Mr. Chair, for giving me this opportunity to address the committee. I am Sherry Boston, and I serve as the District Attorney in the Stone Mountain Judicial Circuit, also known as DeKalb County. Prior to that, I served as the elected Solicitor General in DeKalb County. In addition to those roles, I have the honor and privilege of serving as a member of the Board of Governors, the State Bar of Georgia. I have been in that elected position for almost 10 years. And in addition to that, I also serve as the member of the Disciplinary Board, also known as the Investigative Panel of the State Bar of Georgia. I have served on that panel and in that capacity for the last 8 years as an appointee by the Supreme Court of Georgia. So what I give you all that context because there's been a lot of conversation about the bar, professional rules of conduct, 3.8, what the bar does and does not do, and what the disciplinary committee does. So I'm here to kind of give you all an education about that process and hopefully answer any questions that you may have. Because I think the underlying issue, and obviously, let me start by saying that last summer, really as a result of a lot of the same things that the legislative bodies were seeing and the community was seeing and we were seeing at the bar, I came to Pete Skandalakis, our director, and the DAs, and I said, this is an issue. And as a body of elected prosecutors, we have a duty and an obligation to hold ourselves accountable. And we have a duty to hold ourselves to the highest possible standards, given the job that has been mandated to us. As a result, we formed a committee to examine our own accountability issues and how those could be addressed. I was asked to chair that committee in part because of my involvement of almost a decade with the bar and a very kind of understanding of the process. As a result, we all agreed unanimously, both organizations voted a majority, that we wanted to look at 3.8, special rules of a prosecutor. And in examining and doing a cursory search, we found that the law in Georgia had not been updated since 2008, that 3.8 held a punishment of no more than a public reprimand, that the bill, the bar rule itself, although it did have some rules of conduct, when we looked at the ABA model and looked at across states, there were other states that had adopted much stronger language around conduct. So what we decided to do was to approach the State Bar of Georgia to start the process to increase 3.8, increase the penalties, as well as making it clear that much of the conduct that was concerning could fall under to that rule as well. Having said that, I want to clear up a couple things because I think there is a misunderstanding of what happens at the bar. I think there's a thought that because you don't hear or see what's happening, that nothing is happening. And let me tell you, that is not true. As you know, even with the JQC, with lawyer disciplinary processes, all of these things are kept confidential unless and until they are made public through a hearing or through a ruling by the Supreme Court. And it's my understanding that even this bill as proposed would have those same type of confidentiality involved, because we don't make complaints necessarily public. So I'm here to state in my place. Obviously, I cannot reveal any confidences over the last 10 years of my work at the state bar. But what I can tell you is that our committee has absolutely received complaints regarding DA conduct, both elected and non-elected. We have absolutely investigated those matters, and we have absolutely taken discipline. Keep in mind that some discipline is considered confidential and cannot be revealed. And then there's some discipline that is open to the public. And I point you to, over the years, there are 4 reported cases that were upheld by the Supreme Court of Georgia, which is required for any type of public discipline, where either a U.S. attorney, an assistant district attorney, or an elected district attorney were all subject to some of the highest standards, which were either disbarment or a lengthy suspension. Those things must be signed off. So just to give you an update on 3.8, after working very closely with the Disciplinary Rules Committee, presenting it before the state bar, consulting with the Department of Justice and federal prosecutors, and getting input from our defenders through the Georgia Association of Criminal Defense Lawyers, we presented 3.8 to the Board of Governors this past weekend, and it passed with over 80% of Board of Governors members agreeing to push forward with the revisions to 3.8. Procedurally, the way any rule change happens is the next 60 days or minimum of 30 days, the rule must be published for the public to make comment. The bar has indicated they normally do 60 days, so I see no reason why they wouldn't do it in this case. And then after that, it goes to the Supreme Court of Georgia, who then is authorized to have hearings, receive comment, and they are the final arbiters of any rule change in the state of Georgia. That is the process that we are in, and I am very proud of this achievement and accomplishment that we as prosecutors have stood for and stood up to make sure that we are holding not just electeds responsible, but any and every person that stands in any court and holds themselves out to represent a state or a city as a prosecutor. Having said that, so the natural question is, we're here today on 4/11 creating a commission. And while we as prosecutors believe that we should be held accountable, we firmly believe that there are problems in forming a commission to do the work that can already be done by several agencies. First and foremost, if a DA or any prosecutor commits a crime, they can be held accountable and should be held accountable by way of accusation or indictment, usually led by the Attorney General if it's against an elected official. Secondly, the bar can handle any issues concerning 3.8, which is the breadth of the vast majority of complaints that we have seen against prosecutors. That really only leaves this commission to be an arbiter of prosecutorial discretion. And I think that's the issue we need to be talking about today. Do we think that having a commission whose real sole purpose is to deal with prosecutorial discretion, which is the backbone and basis of those of us that are elected to be either Solicitor Generals or DAs. The backbone of our job is using our discretion to make difficult decisions. And I will tell you that every decision I make every day, no matter what it is, there is a party that does not like that decision. There is a party that feels wrong, there's a party that feels unbiased, and there's a party that feels like justice was not served. Sometimes that may be the accused, other times that may be the family of a victim, Other times it might be people that aren't even involved in the process at all but have an opinion. If we create a commission that's sole purpose really is to look at that discretion, then we are taking away the duty and ethical obligation that prosecutors have to do their jobs. So I would ask, we are in opposition to this bill for many reasons, but I wanted to outline and make sure you understood what the bar is committed to doing and what the bar has actually done. And I will say this, because there's a lot of comparing this commission to the JQC and the bar and what the bar's, how the bar could regulate judges. Let me just give you a little background on that. The bar can regulate legal and lawyer conduct. The bar has never had the right to regulate judicial conduct. So where judges commit violations that were a part and parcel of perhaps their law practice, right, and then become a judge, then the bar can take action against that judge for their legal work. So there are two very different things. And the distinction here is that as district attorneys, there's no distinction between our work as district attorneys and the law. The backbone of what we do every day is practicing law. And everything that we do is governed by the State Bar of Georgia, which is very different than judges. I'm happy to take any questions.
Any questions for Ms. Boston? All right, thank you.
Thank you.
The last person signed to speak on this bill is Tasha Mosley, the district attorney in Clayton County. Good morning.
Good morning. Thank you for having me here and letting me speak. My colleague, Sherry Boston, has done a fabulous job. She hit on several things that I wanted to speak about this morning, but we are completely in opposition of HB 411 for those main reasons. We are partisan. And you're putting us at a position that we take a stance on something that somebody of the opposite party might not like, that they can come after us and file a complaint. Every day, it's a hard decision as a DA, whether or not you're going to bring charges and what charges you're going to bring. We get complaints every day, whether or not they're filed with the bar or they just send it to us personally. Nobody is ever happy with anything that we do. We're already under the confines, hopefully, when 3.8 passes, and it will pass, we're already under the constraints of the bar. So then we're going to be the bar and this committee also with the same rules and punishments. So I'm going to keep it short because Ms. Boston has done a fabulous job. Please reject 411. Let the changes of Rule 3.8 hold us accountable with the state bar and save the citizens of I'm not saying Clayton County, but the state of Georgia about $1 million that it would take to form this committee and run this committee for approximately 120 people. Thank you. Any questions?
We have a question from the committee. Senator Cowsert.
Thank you, Mr. Chairman. So let me ask you this. What do we do as a legislator? When we're passing these bills, we got one coming up on porch piracy in a minute, criminalizing certain behavior, and when certain DAs on their first day in office issue a manifesto that they will no longer prosecute certain categories of crimes that we have made a crime. What is the remedy for that under the current system of oversight?
The current system is to file something with the state bar because we still can be held accountable. Now, granted, it doesn't remove, the punishment does not remove that person.
So they're in office for the next 4 years, not going to prosecute certain categories of crime.
Well, if 3.8 passes, sir.
It hadn't passed
It
yet.
hadn't passed yet. I give it to you. But when it passes, then that person becomes accountable. Trust and believe, we understand. We are not clueless to what some of our colleagues have done and have said. Understand that. We understand that. But there are the actions of a few. And trust me, there have been conversations within our organization with those few to direct. Because when I saw it, I was shocked. I thought it was a joke. And I made the phone call to the person and talked to the person directly because adult to adult, that's what I should do. It's no going behind the scenes. And I made it very clear. Now, some people's minds you cannot change, but that's up to the voters. That is up to the bar. When 3.8 passes for somebody to file a formal complaint and let it go through the process. But we're talking about a major rule change or starting a committee for about 120 of us that are doing what's right. Every day we're doing what's right. The voters made it very clear this past election, for those who weren't doing right, they were out. And then for those who still weren't doing right, we see that there are grand juries about to hold them accountable. So I understand the problem. I understand where you're coming from. But you're talking about doing a committee for $1 million for the actions of one right now, because the rest are gone. I don't think that's best use of taxpayers' dollars when we have a remedy on the table, and God willing, in less than 60 days, it will become what the standard by which we're supposed to be governed.
Senator Kirkpatrick.
I'm not sure if I should address this to you or the previous speaker, but I'm a little confused about why, if everyone knows that 3.8 is outdated and needed to be fixed, that it just, now the process has just passed this past weekend. Is it related to the bill?
Go ahead, Chair.
Sure.
Ms. Boston.
Yes, so in regards to any bar rule, it's a process to change and update that rule. And I also, there is a committee called the Disciplinary Rules Committee of the bar that does nothing all day long but seek guidance and make changes and tweaks to all of the professional rules of conduct. So that issue had not been brought before them. Nobody had petitioned to change that rule until we, the prosecutors, brought it to them and said, we believe that this rule should be updated. We believe that prosecutors should be disbarred for this level of conduct, and we believe it's time for the bar to change the rule. And so, to your question is, there's no one kind of sitting around figuring this out all day. The bar moves forward when any lawyer or any member of the public brings before them the idea that any piece of the professional rules of conduct should be changed. And that's how it happened here. We pushed it.
And just to add on, I was appointed by Governor Kemp in October of 2019. My very first meeting, the winter meeting, this was before the DA's Association in 2019. So I don't know when it started because, like I said, I was appointed in 2019. I was the SG before then, but we didn't have any dealings with that. But it was definitely pushed by the district attorney. So I think the formation had begun in 2019 for that rule to be changed.
Any other questions from the committee? All right, you have no more questions. Thank you, Ms. Mosley. Will the author like to close it out for us?
I would. Thank you, Mr. Chairman. And thank you to the speakers who spoke so passionately about the issue. I think we talked about 2019, Rule 3.8, and we've had some difficult prosecutors for more than the last year. We've had them for years. Things weren't done. This is in our purview per the Constitution to do this. PAC, a lot of people, so dealing with this, I can tell you from personal experience, dealing with a prosecutor, DA, who was just indicted a couple weeks ago. 2.5 years to get him indicted. 2.5 years of my community going through this. The bar did nothing. And that's not, I love the bar. I've worked with them on a number of issues, but 3.8 didn't fix my problem in Paulding County. 3.8 isn't fixing people's problems out in Athens, Clark County for Senator Calvert. They're not fixing other communities' problems with district attorneys. And there are a number of problems. There's more than 4 out there. And to talk to this commission does something that the bar can do. They can remove a district attorney. And I'll speak to one last thing. I think prosecutorial discretion, when we go through these rules, we specifically narrowed it down, totality of behavior, and what those means. It starts at line 142. mental or physical incapacity interfering with the performance of his or her duties, which is or is likely to become permanent. This is basically a restatement of law today, 15, Section B. Someone is in a coma from a car wreck or something. This gives the commission ability to do something. Willful misconduct in office. Willful or persistent failure to perform his or her duties. Conviction of a crime involving moral turpitude. That's also a restatement of law. Conduct prejudicial to the administration of justice, which brings the office into disrepute. A perfect example is my county in that regard. Knowingly authorizing or permitting an assistant district attorney or assistant solicitor general to commit any act constituting grounds for removal under 1 through 5 above. So basically all those rules are held accountable. You're held accountable as an elected. That's why we didn't do every ADA or every assistant solicitor general. You're the elected. You're the one, the buck stops with you. And number 7, violation of Georgia rules of professional conduct of the State Bar of Georgia, including but not limited to Rule 3.8. Which we're discussing. This is just reinforcing what the bar is going to do. And then if you go to courtroom behavior, we specifically specified A, B, C, D, and E, and F, lines 170 through 176, what those complaints can be. And you have to do a sworn affidavit saying this. This is not hearsay. This is not, hey, you know, they prosecuted someone, they didn't prosecute someone else. I'm upset by this. You have to prove this with this being plausible that they did it with undue bias, they did it with lack of probable cause, an undisclosed financial interest, undisclosed conflict of interest, all of those things. Those are vitally important. It really scopes it in. It's not against prosecutorial discretion. It is against saying I'm never going to prosecute this type of crime. But I appreciate the committee listening to this. I ask for your favorable consideration. If I can answer any questions, I will.
Any final questions from the committee? All right, thank you.
Thank you.
What's the pleasure of the committee? We have a motion to pass by Senator Cowser. Is there a second? And it's a motion do pass by committee substitute by Senator Cowser, a second by Senator Watson. Do we have any amendments, Senator Cowser?
I do. Mr. Chairman, I have had legislative council draft, and you've reviewed one that adds a Senate confirmation just like we would on JQC. Most other appointments, I think that gives legislative oversight over this commission to make sure that they stay within their bounds and don't become political, as some people express concerns. You want me to read it or just?
If you'll please read the amendment.
Okay, at line 21, I would add the words, "who shall be subject to confirmation by the Senate," after the word members. And then at line 100, I would insert the language that we ordinarily use in confirmation language, which would read, "the names of the appointees required by this code section shall be submitted by the appointing authorities to the Senate no later than the 3rd Monday in January. Any member appointed to the commission shall serve until the Senate confirms such appointee, and if an individual's name is not submitted by such deadline, he or she shall not be eligible for confirmation. If an appointee is not confirmed by the Senate, the appointing authority shall promptly submit another appointee's name, notwithstanding the deadline expressed in paragraph 1 of this subsection. If the Senate is not in session at the time an appointee's term begins or a vacancy is created, an appointee for such term to fill such vacancy shall be effective until his or her name can be submitted to the Senate and his or her appointment can be confirmed at the next regular session."
We have an amendment from Senator Cowser by way of a motion and a second from Senator Watson. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It passes unanimously. So now we're back. Any additional amendments? We're back to the underlying motion to pass by committee substitute as amended. Any discussion? All those in favor of the motion, please raise your hand. We have 5. All opposed? We have 4. The motion carries. Thank you. Who's going to carry the bill in the Senate? Senator Robertson. Representative, can you do me a favor? Can you please let Chairman Smith know that I know rules is about to start. I have a couple bills sitting in rules, and I can either continue hearing House bills. I have 11 left, or we can end the hearing right now, and I can go present rules and let me know which one he wants me to do. Thank you.
Gullet, if you'd let it for all the members, we'd appreciate that.
Yeah, we'll make that for all of our members. If somebody needs to step out, we will stop the hearing. Thank you. And I know you have another bill coming, but I'll give you time to go tell him that before we call your next bill. Next bill we're going to hear is House Bill 591, second to last in your folder. Representative Hogan, if you want to come up. We are working off of LC 338644.
Correct.
All right, the floor is yours.
Thank you, Mr. Chairman and members of the committee. I come before you today for House Bill 591, authorizing licensed marriage and family therapists to sign 1013s and 2013s. On January 2021, a report from the Georgia Behavioral Health Reform and Innovative Commission recommended this step be taken this year as a way to increase access to scarce behavioral health professionals for people in crisis, especially in rural areas. The Department of Behavioral Health, the Development of Disabilities, DBHDD, the Georgia Psychiatric Physicians Association, the National Alliance for Mental Ill of Georgia, NAMI, all support the legislation as introduced. HB 591 was thoroughly vetted in the House Health and Human Services Committee, passed out of the committee unanimously, and passed the House with only 3 dissenting votes. HB 591 adds licensed marriage and family therapists to the behavioral health providers who now exercise this authority as psychiatrists, psychologists, clinical social workers, licensed professional counselors, and clinical nurse specialists in psychiatric and mental health. License requirements for marriage and family therapists are equal to those of licensed professional counselors and clinical social workers, all of whom are licensed by the same composite board, professional counselors, social workers, and marriage and family therapists. The license requirements include a master's degree, rigorous practicum, internships, additional years of postmaster experience under clinical supervision, and successful completion of a national licensing exam. I understand that there's a substitute or an amendment to have DBHDD to gather additional data and prepare an annual report to the General Assembly as to the number of 1013s and 2013s issued by county, broken down by behavioral health professionals issuing them, and providing a total number of individuals examined in and admitted to emergency receiving facilities designated or used by the department. And I have no objections to the amendment if there is an amendment.
All right, any questions for the author on the bill? All right, thank you, Representative. If you'll sit tight, I have a couple people signed up to speak.
Thank you.
Miss Elizabeth Appling, and I believe there's 2 people mentioned in your entry that were going to be called in by phone. Were you going to?
Well, I think that if you have questions, Mr. Chairman, we'll try and pull them in. We were expecting to be reached a little later.
Okay.
May I offer a handout? I think I.
Yeah, if you.
Thank you.
Would you rather me hold the bill till later in the day, or do you want to go? Okay.
No, sir, I'd like to go
I
forward.
figured you'd
Thank
say
you.
that.
This
Always willing to work with people.
this this is a great group, and I have met with almost every member of the committee in their offices. My name is Elizabeth Apley. I'm an attorney, and I represent the the Georgia Association of Marriage and Family Therapists. We want to thank Chairman Hogan for bringing this bill forward. He has a long professional history in mental health work, and was appointed a member of the Behavioral Health Reform and Innovation Commission, which, as you heard, made the recommendation for this legislation to come forward this year. It has no fiscal impact. The purpose of their recommendation was to increase access to needed behavioral health services throughout the state, especially in rural areas. Georgia now ranks 46th in access to mental health providers as of September 2020 in the country, and we had 149.9 behavioral health professionals per capita for 100,000 population, whereas the national average is 268.6. At this time, we have seen a steady increase over the last 5 years in suicides, and particularly during the pandemic, this has been a crisis. You know, the witnesses who have testified in this bill, who are experts on this, have explained in depth the training and education that licensed marriage and family therapists receive, which is comparable, as the chairman said, to those who are already authorized to act under state law. This authority to issue a 1013 is critically important to help people in crisis when they're in imminent danger to their own lives or the lives of others, and it's been a life-saving access that we're asking for here. I'm happy to answer any questions, Mr. Chairman, and thank you for your consideration and allowing us to bring this bill to you.
Any questions for Ms. Appling? Thank you. Ms. Quick, would you like to come up for a moment? We have in your folder a potential amendment on this bill, and I'd ask if Mr. Dina Quick from Lieutenant Governor's office could address that.
Thank you, Mr. Chairman, and to the committee. I won't take very much of your time to speak to the amendments, except to say that there is some history in the building of expanding the individuals who have the ability to deny individuals their liberty, which is really what we're talking about here, this particular statute. So, Mr. Chairman, I too have the statute in its entirety, if you wouldn't mind me just passing it out to the committee so that they could see how these amendments fit into that structure.
Ms. Park will come get it from you, Regina.
And again, Mr. Chairman, I won't belabor this in terms of the reasons we need good data, but I think, as everyone knows, the Lieutenant Governor cares very much about data-driven decision-making. And so, to put it another way, you can't manage what you cannot measure. So back in 2013, when the Senate bill, when you look at in the statute that I just provided to you, you'll see the legislative history of adding LPCs to these two statutes. Again, this bill, there are two components to it. One is the involuntary apprehension and treatment of someone who is alleged to be mentally ill, requiring involuntary treatment. And the other statute is a certification for involuntary apprehension and treatment for someone who appears to be an alcoholic, a drug-dependent individual, or a drug abuser requiring involuntary treatment. So there are two different aspects to this bill. I won't steal Senator Kirkpatrick's thunder on this. I know she has done some additional research about the national picture here in terms of what other states do in at least one of these categories, which is the substance abuse issue. But all that, because of the much lesser number of marriage and family therapists that are licensed, and Ms. Apley can probably give you the exact numbers, what the amendments speak to is the ability of the state to have good data so that when we start looking at folks that are in crisis, and that's what this is about, which counties it's occurring in, which professionals are providing the services, and that this be reported in a de-identified, aggregated way so that we preserve the confidentiality of the information and the confidentiality of the individuals involved. And Mr. Chairman, I'll be happy to answer any questions or take a stroll down memory lane to the history of legislative history of the expansion to licensed professional counsels as the committee desires.
Can we make it a short walk if we take a
Yes,
stroll?
sir.
Okay. We have Senator Cowser with a question.
Thank you, Mr. Chairman. My mind's kind of going down that lane right now. Just refresh me. This is a provision where a person can be taken against their will to an emergency room to be evaluated for mental illness and held for up to 72 hours with really no due process.
That's correct, Senator. And so this is the apprehension aspect of that. And I think the case laws indicated this is the minimum amount or the maximum amount of due process, the minimum that's going to be procedural due process when someone is apprehended against their will for treatment. That's what a 1013 is. Now, this is a different process. I see Representative Scoggins, I think, and Judge Scoggins can tell us more. There is a two-party affidavit process that you can do through probate court that is different than this. This is a different process. But this is two emergency receiving facilities designated by the department, and that's earlier in the statute. But yes, sir.
So why would anybody go to a family or marriage counselor knowing that there's a risk that that counselor might say, you got a drug problem, you got an alcohol problem, or you're mentally ill, and you're under arrest for 3 days?
Well, as a recovering family lawyer myself, I can tell you that in dealing with marriage and family therapists, they are particularly skilled. This is not an amendment or any sort of philosophical discussion about whether or not they're qualified to do this. That's for the committee to decide. But how it manifests itself typically in my limited experience as a practitioner is that folks would be in the counseling setting and need the treatment, need to be hospitalized. And this is a tool in the toolbox for the counselor to protect their patient from harming themselves or harming others. And so this is probably, as you might imagine, a last resort. I'm not going to speak for them, but a last resort for that relationship. But that would be how it would manifest itself, I believe, and Ms. Apley may be able to speak more intelligently to that than me.
So we're now letting marital counselors make medical decisions as to a person's psychiatric health?
And that is the way the statute is structured, which is why I gave you the statute in its entirety. If you want to look at that, you see that it starts out that this was formerly only a physician could do this, and that's subparagraph A. The expansion of the scope of mental health practitioners who could do this began with D, and of course psychologists, clinical social workers, licensed professional counselors. That was the process the General Assembly went through from 2013 to 2017. And it was a process of data gathering and discussion, which again is tortured, and I won't go through it. But D tells you, sort of explains how this came about. These are the additional professionals who can now do a 1013 or a 2013, and they are deemed to be a physician for the purposes of this code section is the way it's set up. Now, the amendments deal with the report that's required in subparagraph C. of the statutory structure here. You'll see that the General Assembly, once upon a time in a land far away, decided that this was so important that they would mandate that peace officers taking folks into custody for this examination would be required, that's a shall, to execute a written report detailing all these circumstances and make it part of their clinical record. And again, someone who is subjected to this, their remedy is habeas corpus.
All right, last question, just refresh me. Is it the 1013 where you have to believe that that person's an immediate threat to themselves or others?
It is, the standard is set forth in subparagraph A, which is another reason I wanted to make sure you all had it in its entirety. It's the personal examination within the preceding 48 hours and found that, based upon observations, such person appears to be a mentally ill person requiring involuntary treatment. And the companion to this is 37-741, which is sort of a mirror statute, which appears to be an alcoholic, a drug-dependent individual, or a drug abuser requiring involuntary treatment. So
it's a lower standard for somebody to get locked up for 72 hours than it is to be put in involuntary treatment.
Yes, sir.
Okay, so this
That's my understanding.
You don't have to be an immediate threat to yourself or others for this to kick in and you to be arrested against your will and forced to be held for 72 hours and get evaluated.
Yes, sir.
Okay.
Question from Senator Watson.
Yep. Thank you, Chairman. Thank you. This amendment, I think, is great. I'm with you on the data-driven aspect of that, and the Lieutenant Governor. But probably I'm the only person on the panel, except maybe Dr. Kirkpatrick, maybe during our residency, that took that awesome responsibility of having the sheriff take that person to a facility for the 1013. And I've done it very few times since then. And I will tell you, it's not something that we look forward to, want to do, or want to handle. But it is a responsibility that you have to that patient to do that. Because if they're of imminent harm to themselves, and Lord forbid if they're imminent harm to other people, then you have that awesome responsibility of doing that. And it is something that, as a physician, that internal medicine geriatric doctor doesn't necessarily want to handle, but we do at times. Psychiatrists are much better able to handle that. And it is a team effort when it comes to this. And unfortunately, and I'm sure the judge could probably speak to this, it is something that the families should be handling themselves, but many times individuals in this situation have burned so many bridges that the families aren't actively involved. And that's an unfortunate situation. So sometimes it falls upon us to carry out situations where they may be harmful to themselves and to others. So it is not something that anybody takes lightly. From a team standpoint, to have others helping us, and in your situation with the family counselors, or in this particular law that we're proposing, they many times have access to that patient or person they're seeking help, and it is something that they may not have a physician, or may not be tied into the system, and they may be dumped into the emergency room from that standpoint. So it is something that no one takes lightly. It is something, I mean, I hate to say this, but we probably don't do this enough. You know, we have mental health issues in our community, and we have crimes against themselves with suicide, and we have crimes that we've seen, you know, in our community, even here recently, that certainly there are mental health issues. So I'll just leave it at that I would welcome it. I understand the psychiatry community welcomes this. This amendment, and the data-driven aspect of that is certainly welcome. I suspect we will see the data that's driven on this, and I think we will see it. We will see maybe further legislation that could come from this. Thank you so much.
Senator Kirkpatrick.
Yeah, just, I mean, as a hand surgeon, this came into play in my practice when I would see people try to kill themselves by cutting their wrists, or in one case, cutting their hand off. And I've also had people threaten to harm others. And usually it's not me doing a 1013, it's the emergency physician or one of the other people on the list. But these are serious circumstances, and the intent is not to take people in because they're drunk, but it's really about permanent harm to themselves or other people. So I support the amendment also.
Senator Parent.
Thank you, Mr. Chairman. Point of order, I do not seem to have the amendment.
It is this sheet with the bill in your folder.
Okay, so I do have that sheet.
Okay.
And I am not understanding exactly where. So it would be, the statute currently is the top paragraph and the amendment is the latter paragraph?
No, and I'll let, that's why I called Ms. Quick up so it could be explained. But I think we're adding this new language to both those statutes as a new E. Is that correct?
I
Ms.
see.
Quick?
Okay. Thank you.
Does that make sense?
Yeah, I didn't, when I looked at it, I thought it was the same. Since she handed the other paper out, I got confused.
That's why I wanted to
Yeah,
have her
so
speak on
then
it,
I
'cause
lost track of
it's a
what
little-
this was.
This is something that normally you could do as a regular LC amendment, or you could obviously state it what the amendment is. We kind of went somewhere in the middle there by having it in writing at least at the late hours so everyone can
I will
see it.
review it now that I understand where we
Okay.
are. Thank you.
Oh, we have no more questions for you, Ms. Quick.
Thank you, Mr. Chairman.
Thank you. And Mr. Breedlove, you want to be heard very quickly on the bill?
Thank you, Mr. Chairman. I'm down here for another bill, but I do feel obligated on behalf of the mental health community, and many of you know there's over 30 groups that meet every week about this, and what bothers me is that none of them are here because the community didn't know about it. We just were on a Zoom. So I understand this will probably pass, but I do want to put forth a perspective. I'm a person in recovery. Now, I was never 1013, but I know people and families that has been a part of their journey. And we all want to save lives, and we don't want anybody to be a danger to themselves or others. But we're talking about one part of this. If the word gets out in the community that a family therapist or somebody who's not a doctor can involuntarily commit somebody, I am here to tell you I could fill this room up with a line down the hallway of how that will negatively impact people on the front end even willing to engage, and that includes their families. So with respect, it's a little disappointing that the people who bought this, who I know leaders from other organizations that formally I'm not here to speak on, but you all know who they are, weren't briefed on this and given a chance to have input. So I'm up here unprepared per se, but I am here to offer a perspective. I know this will have a potential unintended consequence. And if there were some way to delay the process or in good faith make sure that the leaders of these organizations were at the table before some sort of final passage, I think it would be good for the people of Georgia. I just wanted to put that out there, that the mere fact that I am the only one from the mental health community here today should tell you that not all parties have been involved in this process, and that is of concern, I think, to me, and I'm pretty certain to many, many of your constituents. That's all I want to say on this.
And Mr. Breedlove, on that point, when the bill was in the House in committee, did anyone from that community weigh in at that time on the bill?
Not to my knowledge, sir.
Okay. And as obviously, I respect you and the perspective you bring to the committee and other people you mentioned as well that aren't here. The challenge is the bill, obviously went through the House and has been in our committee since crossover day, and so I hope that if the bill does leave committee today, that those individuals will reach out to us as the bill sits and rules the next few days at least.
Me too. And I understand the process and respect the process. And we are an imperfect community of volunteers and citizens, but I do want the committee to at least have that on their mind as they move it forward. The last thing you want to do is unintentionally scare people away from treatment.
All right, you have a couple questions from the committee. Senator Kennedy.
Thank you, Mr. Chairman. And sir, thank you for being here. I appreciate your perspective. The whole committee does. I'm curious though about the comment that if marriage and family therapists are added to the list of people who can do this under the statute, that there'll be a list of folks down the hallway seeking those people to engage and sign the 1013s. So my question to you is, what's unique or different about adding marriage and family therapists to the list when we already have clinical social worker, licensed professional counselor, clinical nurse specialist? Couldn't those people you're talking about already go to other people on the list to get the 1013 signed? And why the quantum leap by adding of your concern by adding marriage and family therapists to the list that already has multiple people on it that can do this?
Right. Yes, sir. It's a good question. Again, I wasn't prepared to give testimony on this. I wanted to raise the perspective. But I would say that, we heard testimony in a public town hall from a mom in DeKalb County, actually. And people need to know there are some sanctuaries to go to talk about things other than violent crimes and things like that, where the person is their advocate and their ally, and there's no fear of it. And I'm not saying that's perfect. I'm saying practically from people in crisis is what they think, what they feel. And so as we keep expanding who can involuntarily commit people who need help for a medical issue feel like it's no longer a medical relationship or a clinical relationship, that this is, if I say the wrong thing or do the wrong thing or reveal a true deep feeling, all of a sudden I may be involuntarily committed. There need to be some places in our community where people in crisis can say what they need to say to get the help that they need. That's not maybe a perfect answer. I'm doing my best to give you, some of the feelings. I think maybe the answer is there's feelings of comfort with people.
Okay, thank you. Thank you, Mr. Chairman.
Any additional questions, committee? Senator Parent?
Thank you, Mr. Chairman. Thank you for being with us. You may have addressed this, but when we added over the, period before 2017, these other categories, did we see, do you have reports that some of the effects that you're nervous about started happening with these other professionals? I understand that
Yes,
you're bringing
ma'am. Yes,
like
ma'am.
that.
I'm trying to
Okay.
answer you with integrity. I am confident those reports exist, and I'm confident. Of course, I'm one of those that believe you can get any kind of numbers you want in any kind of report. So, I think there are objective academic reports that demonstrate the following: when a person in crisis or a family trying to help a person in crisis feel like they can speak freely, they are willing to seek treatment and help. When they feel like they may be committed against their will, they're less likely to go to that source. Now, certainly we're talking about worst case scenarios, and I think someone said, potentially end of relationships. Maybe it was Senator Cowsert that said that. I'm not sure. And of course, that there's a place in the process for that. There's a place where people in crisis need help even when they don't think they need it, or even if the family doesn't. No doubt about it. Lives need to be saved. But the more you shrink the field of places to go where people feel comfortable, the more you shrink the number of people who are going to go get help in the first place. But I'm sure we can get you some academic numbers.
Senator Rhett?
Thank you, Mr. Chairman. Just out of curiosity, how readily available are these facilities to the average lay person who may feel that they're under undue stress? Because, a lot of times when I look at situations where there was a mental breakdown and a crisis, I see a lot of times the relatives said they tried to find support for them, but they weren't able to find facilities or, a situation where they can express themselves and get comfort.
Yes, sir. Now, I want to say, and this is one of those tricky answers, Georgia does better than most states, and we are thankful for the bipartisan support for years that has happened in Georgia. Georgia can be proud of where they are. We are. Having said that, we're nowhere near where we need to be because you're exactly right. in many of our communities, especially I live in downtown Atlanta. I can walk here. So in urban Atlanta or in rural Georgia in particular, there's a scarcity of resources. There's a scarcity for the average working family or families below that are in economic distress to get the help that they need. So, yes, sir, the perspective that families need help and there's a scarcity of resources is very much a perception in our state.
Any additional questions from Mr. Breedlove? Thank you. Thanks for
Yes, sir. Thank you for
jumping
allowing
on
me
your
to
feet.
speak
Yes,
up
sir.
here. Yes, sir.
All right. Last word, Ms. Appling.
To clarify, this issue was fully vetted before the Behavioral Health Reform and Innovation Commission when they met in the summer and fall. It was fully vetted in the Health and Human Services Committee in the House. The National Association for the Mentally Ill of Georgia has formally endorsed and testified in the House Health and Human Services Committee, as well as the psychiatrists, and the Department of Behavioral Health and Developmental Disabilities also in support. The 1013 form itself specifically requires that there be an examination within the preceding 48 hours that, in my opinion, this individual appears to be a mentally ill person requiring involuntary treatment, in that he or she appears to be mentally ill and A, presents a substantial risk of imminent harm to self or others, as manifested by recent overt acts or recent expressed threats of violence which present a probability of physical injury to self or other persons, or appears to be so unable to care for his or her own physical health and safety as to create an imminently life-endangering crisis. We also reached out to the Mental Health Association of Georgia, to the psychologists, none of whom expressed any opposition at any point in the process. The purpose of this is absolutely a last resort. It is something that is exercised very reluctantly. It's not an involuntary commitment. It's a referral for an emergency evaluation with a final decision made by a psychiatrist or a psychologist. And we appreciate your seriousness in addressing this issue. We have no opposition to the amendment, and the research from other states confirms that there is no increase in the number of people committed. There was a Florida study done, and I'm happy to share that with the committee, specifically following the addition of licensed marriage and family therapists. What it does is remove the obstacles for those people who otherwise wouldn't be able to get this emergency care from the people who are treating them and know them and are able to respond in this emergency crisis. One of the things the practitioners tell us is that when they have the authority to 1013, very often the patient will then voluntarily cooperate and receive that emergency evaluation rather than bringing law enforcement in.
Last question, Senator Kauser.
All right, I think y'all are blending two different things. The 1013 is after the evaluation.
Yes, sir.
And they're then involuntarily committed.
No, sir.
That's after they've been examined and a doctor or somebody, psychiatrist, says you're a threat to yourself or others.
This is the process, Mr. Chairman, as I understand it, and I've researched it thoroughly. The person signing the 1013, that is the psychiatrist, psychologist, licensed professional counselor, clinical social worker, APRN in psychiatry, and with the addition of this bill, the LMFT, must have examined the person within 48 hours and made the determination and documented in the way that I just read on the 1013 form. It's an order for an involuntary transportation to an emergency evaluating facility. They can be held there for up to 48 hours, within which time the psychiatrist or psychologist must make the determination whether or not the person requires an involuntary commitment.
Okay. But this includes drug and alcohol things as well.
Yes.
In this bill. This is the stage before they're put in for treatment. This is where they're being taken against their will, forced to undergo this evaluation.
Yes,
right?
sir.
Okay.
But they have been evaluated by the professional authorizing the 1013.
And so what you say the Florida data shows is after allowing family counselors and marital counselors to start this process, there is no increase in the number of people that are found to be a threat to themselves or others and involuntarily committed.
They're looking at data. It was over a short period of time, and it looked at what it says is that there are people who are then, that it didn't result in more people being suicidal. It didn't result in more people needing to be committed. What it meant is that there were more people who were able to access that care from the treating professional who knew them and observed them. That the point of this legislation is not to increase the number of people 1013. It's to make sure that people who need it receive that care. What happens, according to the testimony that's been provided in the other committee, is that if a professional is not able to exercise the 1013, they have to bring in law enforcement, at which time the patient says, oh no, they gather themselves together, oh no, I'm not suicidal, I'm not going to kill my next door neighbor, at which time they go home and then they commit suicide. And so what you'd have to look at is what happens if you're not able to exercise the 1013.
Well, it sounds like what you're saying is what has happened in other states that have allowed this is people are being falsely accused of being mentally ill and needing treatment, but when they go get evaluated after being confined for 72 hours, they're told you don't need treatment. If the numbers of people needing treatment don't go up after allowing them to be referred by additional categories of people.
So the data was not looking at who ends up involuntarily committed. The period of time for evaluation in the evaluating facility is 48 hours, and the issue is whether or not we can get the people who are in crisis and need that care from the professionals who are treating them, who have comparable education, training, and experience, to make that judgment, to allow them to access that emergency care. It did not look at a change in the number of people who subsequently were involuntarily committed. No one wants someone to be involuntarily committed that doesn't absolutely need it. And it's true that in that 48 hours of evaluation, when the psychiatrist or psychologist is evaluating them, they're also treating them, and many people can stabilize.
All right, any other questions from the committee? Thank you, Ms. Appling.
Thank you, Mr. Chairman.
Could I just make one or two statements?
Is it two statements? Yeah. Okay. We're going to count the statements.
I worked in the
Mr.
crisis
Chairman.
line for 12 years doing evaluations in the emergency room. And at that time, the doctor had to sign the 1013, but I did the evaluations and made the recommendations to him. This is not going to solve the problem we have in Georgia. We have a crisis of mental health in Georgia right now. And it dates back to us doing away with the facilities. And we had to do that because of the Justice Department. We have people out there that are hurting and they need help. This is not going to solve the problem. We've got to look forward to trying to do something else. And I don't know what that's going to be, but we've got to try.
And Mr. Chairman, you have several bills you filed this year to directly address these issues that came from the commission that we voted on. Was it last year, the year before last, 2 years ago, I think it was?
Yeah, I
right?
filed a bill every year that I've been up here. House Bill 178 and 590 this year that I did not get a hearing on in the Health and Human Services Committee.
Well, this is a piece of what's been recommended, a small piess by that commission, correct? And,
right, it is.
All right.
And I'll be dropping some more legislation next year to try to help out with mental health issues.
Senator Parent.
Thank you, Mr. Chairman. Your legislation that didn't get a hearing, were those other pieces recommended by the
Yes.
behavioral? Okay, thank you.
AOT, assisted outpatient treatment, which is one of the things that's been done in other states, New York, Ohio, and North Carolina, that's been very successful in trying to deal with mental health services.
And make sure we're clear, that was the House that wouldn't give you hearings on those bills.
Right,
correct?
it was the House.
Maybe we'll have a shot in the Senate next year. We have a chairman on the committee, I think, even. Okay, what's the pleasure of the committee on this bill? Motion do pass by Dr. Watson. Is there a second? Second by Dr. Kirkpatrick. Does someone want to offer an amendment? Senator Kirkpatrick? Never mind. Senator Dr. Watson, do you want to offer the amendment as it is drafted in our folders?
Yes.
Do we have a second on the amendment? Second. We have a second by Senator Kennedy. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It passed unanimously. Now we're back to the underlying motion. Do pass as amended. Any discussion? All those in favor of the motion, please raise your hand. 1, 2, 3, 7. Am I counting right? 7. All opposed? To 2. Motion carries. Who's going to carry the bill in the Senate? Senator Kirkpatrick. All right. Thank you. We have a special guest I want to recognize that's with us right now, our Majority Leader, Mike Dugan. You want to stand up and be recognized? Okay. I remember when I was in school, sometimes someone would sit in the back of the room and the teacher always get a little nervous, and it was when they're being evaluated. Is that what's happening right now? There you go. And we'll see if I pass the test. That's what they always say. Let's take a 3-minute break, and we will come back in 3 minutes. Can come back to order. All right, we're going to come back to order. I don't have a gavel. That doesn't work. Mr. Leader, can I get a gavel for next year? Talk to Blake, okay. No respect whatsoever. Huh. Okay. The next bill we're going to take up is House Bill 334. You have a substitute that has arrived that's been passed out. You come on up. We are working off of LC 413158S. And Representative Fairness, you just got handed the substitute, so
I did.
I understand you may want to present your underlying bill, and then I will call on Chairman Tillery to address the substitute. So the floor is yours.
Thank you. Yeah, so my LC before was 3007S, but I'll talk to that. And then, so I just want to kind of go over a little bit about the background of where we are, how far we've come, and kind of where we're at up until the substitute just a few minutes ago, if that's fine with you guys. Like all of you, I have a day job outside the legislature. Mine happens to be working with technology, and most of what I do is designed to make it efficient and more convenient for people to do things. So my county IT's director came to me for business licensing and said, hey, we're a bedroom community, and said, hey, we're trying to tell people in sell Paulding County to say you can get your business license really easy in Paulding County, even at 2 in the morning. But the problem is, for whatever reason, we have notary involved with that, and 2 in the morning notary is not likely to happen. So what can we do about it? So we did a little research, found out a bunch of other states have done this. Majority of other states have done this, and so said, pretty naive to say, yeah, let's do it. I'm thinking it's going to go to science and technology. Here we are in Judy. So here's where we are. 2 years later, as a matter of fact. Several facts that I think everyone will agree on. One, remote online notarization, or RON, is a broadly used tool that is generally much more secure than ink notarization. It's been in use for some time in the United States, and the technology is extremely good. And if the validity of an ink notary is disputed years later, you're stuck arguing about personal recollections, signature matching, and maybe a copy of a photo ID. If electronic notaries are contested, you have a detailed electronic record of the act, digital identity verification, and an audio-visual recording of the entire act. RON provides a significantly higher level of security to all parties in the transaction, and it also obviously makes transactions faster and more convenient, particularly when the parties are located long distances away from each other during a pandemic. And finally, if anything ever happened where there's dangers to put 6 people in a conference room together, remote online notary gives us a tool to conduct business without having to meet and share our germs with one another. This is now the second year we've been working on this bill. After it failed last year in the House side, brought the parties together, and we spent over 100 hours working on this, largely on video conferences, painstakingly going through the bill to refine every element, prevent unforeseen consequences, and build consensus. Every party that expressed any interest in the bill had an open door to propose changes, and we worked very hard to get a near unanimous consensus. I want to thank the State Bar, the Real Property Section, the court clerks, state banks, credit unions, title insurers, and others for rolling up their sleeves, giving their time. I also want to thank Georgia Chamber, Metro Atlanta Chamber, Technology Association of Georgia, and the Office of the Governor for their proactive support on the final passage. We're really down to, at this point, to one small group of attorneys who have chosen to oppose the legislation to prevent the clients they serve from using this tool. Georgia Real Estate Closing Attorneys Association, GRECA, has tried to work with a group of stakeholders to address their concerns. Initially, their lobbyists told us that if they were able to provide a strong remedy for unlicensed practice of real estate law, that GRECA would support the bill. We worked closely with the State Bar to craft language, lines 510 to 515 on my version, that strongly states that the online notarization cannot be used to erode our legal practice standards in the language at line 510 through 515 that provides a remedy if a person records a deed in Georgia with the knowledge that it was not prepared by a Georgia licensed attorney. And I agree with GRECA on this point. If we're going to require that attorneys protect the interest of consumers by supervising real estate transactions, we ought to have a meaningful solution in place to enforce those laws. This language does that, and it provides significant protection for closing attorneys that they will not otherwise have. Unfortunately, after we added this, Greca moved the goalposts and changed its position by insisting on a requirement that only Georgia licensed notaries could notarize Georgia real estate transactions. Despite opposition from many stakeholders and some personal concerns about this provision, I agreed to add it in the House version. However, the State Bar analyzed and concluded that it would create a significant threat to the validity of real estate title in our state. Needless to say, we could not include this language in the House and cannot add it in the Senate without killing the bill. Many of you may have heard from local closing attorneys who've been told by Greca that allowing for online notarization will result in harm to their business. This is a scary thought and one that we should certainly be alarmed by. Greca is now trying to lever that fear into getting you to vote a bill down or amend it to exclude real estate transactions. I'm sure Greca will offer testimony to this topic today, and that each of you will carefully weigh your decision. Just to give you my perspective, I want to make the following points on this request. Greca is far from the only voice speaking for real estate attorneys in the state. It includes a relatively small number of real estate attorneys, much smaller and less inclusive than the State Bar. The Bar supports this bill and supports having RON as a tool for real estate transactions. I have heard from real estate closing attorneys across the state who want RON as an option, and I hope that they've emailed you guys too. And several of them have signed a letter to that effect making this request. Closing attorneys provide a valuable service to Georgia's citizens, and this bill is not going to harm their economic interests. In fact, having the ability to use RON will help real estate closing firms in Georgia compete by giving them another tool to use. Remote online notarization software is standardized, requires no customization, and can be downloaded in a few minutes. Any Georgia attorney can use this tool if you make it available. Number 3, virtually every business that pays closing attorneys to perform closings wants this bill. Banks, credit unions, title insurers, mortgage bankers, and businesses large and small see it as a simple convenience that they can offer to get transactions, especially real estate closings, done in a more convenient way. We've been doing virtual notarizations for several months under COVID emergency provisions, and the sky has not fallen. Closing attorneys are still in business and they're still making payroll. Lobbying for an amendment to take this tool away from their clients will only hurt the interest of the clients and the parties to the transaction. Number 4, as a general principle, hope we can agree that businesses should succeed based on the value of the service they provide and not based on the hiring lobbyists and getting a law passed to force people to come to their offices in person. The numerous other states with RON have robust closing attorney industries, and the UPL remedy included in this bill should give Georgia attorneys added insurance that their interests are protected because it will allow them to be proactive and go protect those interests. We have worked this bill to get into a very solid place. It's a tool businesses and consumers across the state want to have, and I urge you to move forward with the bill so we can demonstrate that it's absolutely possible to modernize our transactional process in a small way. And I'm happy to go through the sections of the bill I have. I don't know how many changes were made before, but if you want me to go section by section, we can talk about it, or I can answer questions to the sections that didn't change.
Let's start with questions, and then if we
Sure.
have requests for you to go through some of the sections, we'll do that. Senator Tillery.
Thank you, Mr. Chairman. Thank you, Representative Gullett, and thank you also for working with me on this one. You mentioned one group opposing this bill. You mentioned Greca.
Right.
I want to state I didn't know of Greca until a day or two ago. I'm not a member of Greca. I do have
Sure.
some issues with your bill.
Right.
I'm sure we'll talk about.
Yep.
Is there any member of Greca or somebody representing Greca in the room? Okay, just making sure we had somebody here. Is there anybody here representing the other side of that bill? The side that you're on? If they'd raise their hand? Okay, you made Greca sound like that because you made a comment about you didn't want anything to change because people were able to hire a lot of lobbyists. And I just wanted to make sure I understood how the room was divided, but thank you for that. The second thing is on...
There are a few more around here too.
That are on your side? Well, heck, I
No,
just pointed out 20.
that are Greca.
We'll
I
stop at
never
that.
heard of Greca
If you want to
either.
add more, I'm good with it. You mentioned this bill started off as allowing notaries for business licenses, helping with business license. Would you agree with me that it has gone a long way from allowing business licenses to be notarized?
So that was the start of it. Yes. So it has gone a long way, and initially, I'll be frank, I had enabling legislation is all I wanted to do. Initially, I'm not an attorney. Once I found this, went to Judy. You can tell by talking to me, I'm not an attorney, right? So, I wanted enabling legislation. I think a number of states have done this. They've done it too rigidly, and they weren't able to actually implement it. And so my very first draft was I didn't even drop it that time, but we've gone through a number of iterations. Basically, what I found out is that notary does affect the legal side a lot more than it does the average Joe. And so the legal side has weighed in very heavily on this for changes. So that's where we found where we are
answer
today.
another couple of questions. The next thing is I took and looked back. I heard rumor that your first iteration of this bill was just one page. Do you remember?
It's probably a little bit longer, but close. Like I said, it was enabling legislation to let all the rules and regs be written by the clerk's court authority.
And then I found an iteration last year where you had a version of this bill that was 9 pages that I believe still stuck close to what you were talking about, allowing business licenses, et cetera, to be notarized. Do you remember it was about 9 pages?
Yeah, it could be.
And now this year we've got a bill that's about 21 pages.
That's right. Hundreds of hours with lawyers. That's what happens.
There's a lot of people who want to tag on to this one, isn't there?
I don't know if tag on is it. I think there was a worry in the legal world. Definitions are important. I think we probably got 3 or 4 pages of definitions, and people don't. What we found is a lot of people want to know specifically what they can and can't do, and they were worried about giving that authority to a board. So they wanted, from a legal standpoint, to know exactly what the guidelines are, and that's kind of the model across the U.S. But it has gotten longer. That's right.
You spent a lot of your time talking about the exemption for real estate. In fact, I think that was the majority of your testimony, correct?
Not a majority, but a good piece. Yes.
There already is one other exemption in this bill.
That's right.
The bill that you proposed, correct?
That's right.
And that's to wills, trusts, estates, et cetera.
That's right.
Could you explain to me why you thought that was a good exemption?
Because every other state pretty much has that exemption in there. So ideally, I wouldn't have that exemption either. I don't think, in a perfect world. But every other state has done that, and so I think there's been some lessons learned. We're not leading the pack on this effort. We're actually behind as Georgia, and there's a reason that they did that. So across the board, every other state's done that. So maybe Virginia hasn't.
Do you know why they exempted wills, estates, et cetera?
No, I don't. I don't.
Thank you.
Sure. Thank you.
Chairman Tiller, never got to see you in court before, but maybe that's
I'm on the trial, baby.
I know. I was waiting for Judge Kennedy to give an objection I made, but
it was all relevant.
It was relevant. It was sustained, though. No other questions at this time from the committee.
Thank you very much.
Chairman Tiller, do you want to address anything else on the substitute? Do you want to
Sure,
at this
I
time?
will.
I think it'd be better before we have witnesses come up.
Sure. However you'd rather me do it, Mr. Chairman.
The floor is yours, Mr. Chairman.
Well, thank you. The bill, I think, in our folders is LC 413157S, but you'll also see it was handed out LC 413158S. So I guess I monopolized the time of legislative council last night and got them back to back. I want to walk you through the changes that are in 3158S. You'll see the first change appears roughly on your bill in line 41. It talks about the definition of what a pier means. A pier can be physically in the same location. That was defined. It was understood before, but it's defined here now. And it was defined in the underlying bill. It's defined in the substitute here. But we also added before B, for remote online notary purposes, before the word interacting in letter B, to make sure that when you're talking about for communicative technology, interacting with an individual by communication technology is for remote online notary purposes. The second change in the substitute with the last numbers 58 would be to on lines 202. It's talking about the training, and it says that the 202 there's got to be a course that's taken so you can get this, etc. And it says the words added at the end of line 202 that and neither the Georgia Superior Court Clerks Cooperative Authority or the clerk may charge a fee for the training. Again, trying to stick to the original intent of the author. I saw where he had in the original that the fee for the online notary and the fee for the regular notary were to be the same. Straight after that, you'll see in line 203 the substitute strikes except for remote online notary public as appointed under subsection H of this code section, because later on we're going to strike subsection H, and I'll show you that when we get there. The next change is on lines 222. It strikes number 6, lines 222 through 224, and that again is reflected in the substitute 58S. Yeah. Sure.
Hold on.
Okay. So I'm going through 357 that was in our file and marking the differences from 357 or 3157 to 3158.
Are y'all clear? Yeah,
Okay.
he showed, so just so everybody's clear, we do our best, even though things happen fast around here, to give everybody notice of the LC we're going to hear, so people aren't surprised by an LC they get handed. It's happened to all of us in committees. Nobody likes being in that position. I know you don't like being in that position today. But what we did here, because there's a late arriving LC that's different from what we gave notice of, we're having Chairman Tiller explain the difference between the LC you were noticed on and the one that he brought today.
Do I need to start earlier on and go back through them again, Senator?
Not necessarily.
Okay.
The lines that you're giving are not matching up with the text that you're reading.
So if you're looking at 357, I'm reading the lines off of 357 and telling you there is no additional language in 358 unless I read it to you off of where we put it on 357. Does that make sense?
Yes.
So I'm reading you the red line of 357 as it's reflected in 358.
357S.
357S.
And I only had 358.
Yeah, that was the one in our file.
Yeah, do you mind? Sky's going to bring you
Thank you.
a copy of that too. Senator Parent.
While we're doing that, Chairman Tillery, could you quickly run through the change in starting on lines, I think it was like 202, 203 again?
So I'm going to read off on 3157. We went into line 41 and added for remote line online notary purposes, which now is reflected on line 38 of 3158. The next change would be on, again, off of 3157 at line 202, and I'll tell you where that corresponds on 3158 in just a second. $199 200. At the end of 200, let's see, you'll see it's added, or on 358 it's added, and neither the Georgia Superior Court Clerks Cooperative Authority nor any clerk of Superior Court shall charge a fee for such course. So that's reflected on 358. Staying at that same point on line 253 of 3157, but line 201 of 3158, we struck the words, except for a remote online notary public as appointed under subsection H of this code section, because later on we'll delete subsection H. Okay. On 3157, line 222, we struck number 6, and number 6 stated that things that were to be included would be the business address of the applicant in this state if the applicant is a resident of a bordering state. Because again, we're talking about Georgia notaries, not expanding and allowing Alabama notaries to become Georgia notaries for purposes of the remote online notary.
What line is that?
It's on line 222 through 224 on 3157, and it will not be reflected on 3158 because it was struck in its entirety. On 3157 at line 270, we strike subsection H, which again was the subsection I told you about that while we struck the line earlier saying except for included in subsection H. And subsection H says, any person who is a resident of a bordering state of Georgia who carries a business license in Georgia or professional in Georgia who's regularly employed in this state may be commissioned as a remote online notary by the clerk. Superior Court in the county which the person carries on the profession. Again, if you're an Alabama notary, you're an Alabama notary, you're not a Georgia notary, if we're going to make these match up. The next change to 3157 was on lines 343, and it's going to be a strike, so that won't be reflected on 358 in 3158. But this section's talking about where how a notary can notarize things. And it says, subsection A, if the notary public is physically in the state of Georgia, they can perform electronic in-person notary. In B, it says if they are physically located in this, A, they can, if they're in this state and the person is in this state, they can do online notary, which I believe was the way that the governor's executive order originally read. B says a remote online notary, if the remote online notary is physically in the state and the other person is physically located in the state or outside of this state but within the United States, and then says or outside of the United States if, and this is where it gets really funny to me, if the remote online notary has no actual knowledge that the making of the signing or statement is prohibited in the jurisdiction in which the person is located. So in other words, it's like ignorance is bliss to me on that. If they don't know you can't sign, then they can notarize it. Or by doing this, that it has something to do with some other court document or other transaction that's related to the United States. And that provision just seemed to be, because of A, seemed to be quite an expansion of what the governor's executive order originally was. And so it strikes, the version 3158 strikes lines 343 through 352. Again, the big part there being, so the notary gets to not ask whether or not you have the ability to sign, and then they can notarize. That just doesn't feel right. The next strike, if you're looking at 3157, is on line 381, and we strike the words, provided, however, that a failure to provide an accommodation shall not invalidate an otherwise valid notarial act. And I want to read to you why that matters. So if you read it in its entirety, what we're saying is if the person did not have the ability to notarize that document, that they then the notary is then valid because of they didn't necessarily follow up and make sure the person was the person. And I don't think that that's exactly what we meant to do. So I struck the words provided, however, that a failure to provide an accommodation shall not invalidate an otherwise valid notarial act. The next strike gets to the comments that Representative Gullett made on line 404. We struck the words 1 to 4 person residential, so that it reads that this remote online notarial act is not able to be used for wills, codicils, testamentary trust, or for the purpose of recording a recording a real estate document as defined in OCGA 4517(1) paragraph 18, which is again defined earlier. Yeah, it's on 3157S, it's lines 404 and 405. So it adds to the exception that's already there, wills, codicils, testamentary trust, and then it basically strikes the 1 to 4 residential so that it's for real estate documents in total as defined under paragraph 18 of OCGA 4517(1). The next strike, if you're looking at 3157S, is at line 438. This section says that a remote online notarial act performed in another state has the same effect as it would if it was basically that Georgia had to say, yeah, we're going to file that document too. The problem I see there is we've mentioned all these things. I think Representative Gullett did work to try to limit this to Georgia. However, if you include 438 through 440, your issue now is the online notarial bills of Nebraska and Maine and California, et cetera, have to now be accepted in Georgia, so you're not tying it to make sure there's a Georgia nexus with a Georgia attorney or a Georgia online notary public. I'm afraid 438 through 440 essentially guts the other protections that the good representative included in his bill. And then in line 444, we just added the definition again to real estate document, and it said as defined in OCGA 4519(1) paragraph 18. Mr. Chairman, that's the last change I'm going to present to you, and it's, if you look at your version 3157S, we struck lines 473 through 477. That section read, any instrument presented to a clerk in Superior Court for recording, recordation that requires an official and unofficial witness set pursuant to another paragraph that we talked about earlier, may be admitted to the court record if apparent signatures of both witnesses and any required seals are present on and in such document. I present to the committee that that is a major change from Georgia law. Right now, the clerks look at those documents, make sure that the witnesses their signatures are there, that they're not the same person, that the notary stamp is there before that document is filed. And if we strike those languages, you could end up with a situation that we actually saw in Cobb County. And in Cobb County, I have copies for members of the committee if you'd like one. I'm sorry, I thought this was appropriations for a minute, Mr. Chairman, but thank you. In this is a durable power of attorney that was used for a real estate closing in Cobb County. And it was attempted to be used on a residential closing. The lady was in the Dominican Republic. In the Dominican Republic, they require a judge to get an online notary approval. Well, because of different things going on here, someone instead got the notary to sign, and if you look on page 2, you'll see that the notary also happens to be the witness. So if we pass this bill as it is, this would have been a valid durable power of attorney. It would have been a valid closing for a Cobb County residential closing, which is not anything that our laws have ever anticipated here in Georgia. Remember, in Georgia, we're still one of a few states that's an attorney closing state, not a title closing state. And because we are an attorney closing state, the attorney in Cobb County on this one caught this, realized, hey, you can't be the witness and the notary, and they were able to get it fixed before the deed was filed. That's the protections that we've put in place for over 2 centuries here in Georgia to protect closings. And while I completely support Representative Gullett's position of moving to make business license easier to notarize and other documents, I present to you that the exact reason that we've included wills in this exclusion is the exact reason we should include real estate closings in this bill, because those are usually the largest investments that any of our constituents make. And if we're going to include their last will and testament so that one day we, again, have for the exact same reason, we should exclude real estate closings. And Mr. Chairman, I appreciate your indulgence and the indulgence of the committee.
All right, thank you. At this time, yes, sir.
Yeah, so just wanted to clarify. I appreciate that, Senator, for going through that. Attorneys are still part of the process with a remote notary. An attorney caught that with a traditional, however it was done, and an attorney should catch that with a remote notary too, what happened wherever that Dominican or wherever that happened. So I just want to point that out. Attorneys are still part of the process. We're not removing the attorney state from this in any way, but I appreciate your going through that a lot better than I could. I'm still not sure what it does exactly, so I'll read through it, but thank you for that.
All right, this time we're going to take testimony in the bill. I am going to limit testimony to 2 minutes because of our limited time. Because if we don't do that, then we will not be able to get to the rest of these bills today. And so I respect your colleagues. I'm going to do that for you.
Yeah, thank you.
And so the first person out to speak, Gino, I'm sure you'll tell us your last name.
Yes, sir.
Good morning.
Good morning. I'm sure Garner's going to join me up here. Hi. Thank you, Chairman and committee member, Judiciary Committee members. I am Gino Yaskovitz. I'm the Director of State Government Affairs for the Rock family of companies, which includes Rocket Mortgage. We are the largest lender here in the state of Georgia. We are also the largest mortgage lender in the country. I had a lot more in my testimony, but I do want to hit on some points I think is important. The striking of the recognition of remote online notarizations from other states that's standard practice in many of these bills that have been drafted. I've worked around the nation for the last 4 years on all the remote online notarization bills that have passed, and that provision is pretty standard for those things and the acceptance of that. Our goal as Quicken Loans and Rocket Mortgage is not to exclude the attorney from the closing process. We want to make sure that the client is taken care of, and this adds a choice for the client and security. And so we ask that we don't have any exclusions to this. Georgia would be the only state left if we do pass this bill, would be the only state that has that real estate exclusion. Other states that have passed RON bills are looking at bringing up the e-wills. Florida actually is looking, they had excluded e-wills in the beginning, but they came back this session and actually are working through a bill to allow for e-wills. I could go through a lot more, but I know we're cutting it short. Cherie, you want?
Good morning, Mr. Chairman, and thank
Yeah,
you
Ms.
so much
Garner.
for allowing us to speak here today. My name is Cherie Garner. I am the Regulatory Counsel for Quicken Loans in the Rock family of companies. I am a former Georgia closing attorney, so I have a lot of experience in this area, having closed hundreds of millions of dollars of loans here in the state of Georgia as a closing attorney. And so we do oppose the exception for a real estate carve-out, primarily because the Georgia attorneys are not removed from this process at all. They are part and parcel. You are responsible for the closing from beginning to end. You have exclusive jurisdiction and responsibility and supervision responsibility for the transaction from beginning to end. And if I might add that when we do the closings, the notaries are selected or facilitated by the closing attorneys. I've never had a client come to me to say, oh, I have my own notary. And so in this instance, it would similarly be the same. The closing attorneys would naturally be facilitating that process. And so to that extent, and we included that in the bill that was dropped by Representative Gullett, which we really appreciate, that in the UPL language, as well as it was in that version, it was section 4517.810. It refers to the unlicensed practice of law, and it refers to the fact that a Georgia attorney has to be responsible for the process from beginning to end. So the other piece is that this really does also come down to choice when you're talking about remote online notarizations. This is not a mandatory process that has to be included in a transaction for real estate. It is more of for convenience for a client. If you are a closing attorney, you feel uncomfortable with doing the remote online notarizations, or you just don't want to invest in the technology, if it's not something that's part of your business practice, you don't have to use it. But as a former closing attorney and as someone who works for a very large company, and we originate the largest volume of loans in the state of Georgia, understanding how the convenience factor that it does provide for the clients is immeasurable. And the fact that the remote online notarization provides an audit trail, video, it gives you everything that you need to be able to trace the transaction that minimizes and mitigates any opportunity for any fraud or anything to take place. So that's one reason why we're in support of the bill, and we would strongly encourage you to not accept an exception for real estate.
Thank you, Ms. Garner. Any questions for either of the first two speakers from the committee? All right, thank you. Next, we have Ms. Lori Godfrey with the Community Bankers Association. Good morning.
Good morning, Mr. Chairman and members of the committee. I'm Lori Godfrey, and I work with Community Bankers Association of Georgia, and I come to you today in support of House Bill 334 as it was presented by Representative Gullett. In light of the events that occurred with COVID-19 pandemic, it is clear that the ability to perform remote online notarizations are a crucial tool for financial institutions that have available if, God forbid, another pandemic were to occur. The emergency order signed by Governor Kemp was a vital part of keeping the Georgia economy afloat by allowing real estate closings to occur with an e-notary, and our community banks are thankful for Governor Kemp's foresight in this regard. As we come back to the legislative session this year, we knew that this would be a key piece of legislation that would be debated here at the Capitol. There are a lot of conversations taking place regarding the details of this legislation, and I'm sure that there are many tweaks that we could make to the legislation to take it from workable to perfect. CBA has been in conversations with the author of the bill and many interested parties involved in this legislation. We have expressed concerns and listened to the concerns of others, and Representative Gullett and other key stakeholders have done a great job in managing the many and sometimes conflicting voices. While not all of our concerns are addressed in the legislation pending before you today, we respectfully urge each of the members of the committee to vote do pass on the original legislation and play a part in ensuring that Georgia's economy can continue to function in the event we find ourselves in a remote working environment again. It is our opinion that the concerns, as well as many other concerns, can be addressed in future legislative sessions with the benefit of hindsight following the implementation of this legislation. But we would oppose taking out real estate transactions, as we do believe this would be a vital part of having the remote notary. And I'm happy to take any questions.
Thank you, Ms. Godfrey. Any questions for her? Thank you.
Thanks.
Next person signed up to speak is Elizabeth Chandler with the Georgia Bankers Association. Good morning, Ms. Chandler.
Good morning, Mr. Chairman and members of the committee. Thank you very much for the opportunity. I'm Elizabeth Chandler, and I've worked with the Georgia Bankers Association. And as Ms. Godfrey stated, financial institutions are in support of the underlying bill here, and including the ability on real estate transactions to utilize a remote notary. And again, emphasizing the nature of using the notary not being mandatory. So in each transaction, that would be up for discussion. So with that, I'll just make it quick and voice our support.
Thank you, Ms. Chandler. We have a question from Senator Parent.
Okay.
Thank you, Mr. Chairman. The section that the sub strikes dealing beginning on 343, notaries outside the United States. Why is that needed? Or what's your, I'm trying to understand the issue more about why we have in here about notaries outside the United States.
I'm sorry, I just can't speak to that. Is that in the proposed substitute
No, it's
or
in
in the underlying bill?
It's in the underlying bill.
Okay.
Okay,
Not much
maybe
help there.
someone else will have
Okay.
that. Okay, thank you.
All right, thank you, Ms. Chandler.
Thank you.
Next person signed up to speak is Mark. Is it Saeb? Sieb.
Thank you.
With GRECCA. That's your group, Tillery.
Good morning, Chairman Strickland and committee members. I would like to thank you for the opportunity to appear before you today regarding this important piece of legislation. As you mentioned, my name is Mark Sieb, and I'm here in my capacity as president of GRECA, the Georgia Real Estate Closing Attorneys Association. I would like to start by thanking Representative Gullett for authoring the bill, for all the work that has been done in the months prior to the bill's presentation in the House, and for allowing members of the real estate section of the bar to provide our input during the legislative process. The idea of having remote online notarization available in Georgia is very appealing. Having lived and worked through the past year where COVID-19 has had such a profound impact on our personal and work lives, the need for this technology is abundantly clear. And when it comes to more ministerial acts, such as applying for a fishing license or a building permit, the use of RON makes total sense. However, when it comes to the closing of residential real estate transactions, our organization feels the implementation of RON is premature at this time. On behalf of GRECA, I would like to state that we are in support of the substitute bill as presented by Senator Tillery. Thank you.
Any questions for him? Thank you. Next person signed up to speak is Brandy Bickle with Georgia's Own Credit Union. Good morning.
Good morning. Good morning, committee. Thank you so much for spending so much time on this issue today, and thank you to the bill sponsor for the eons of time that he has committed to this particular issue. My name is Brandy Bickle. I represent Georgia's Own Credit Union. I am here in support of the bill, the idea of the bill, and all the effort that's been put forth in it, because it truly is meaningful for Georgians. When it feels a little bit like deja vu right now, because when we were sitting in the House Judiciary Subcommittee mid-March last year before COVID and watching this bill go through a similar, I think the word buzzsaw was what I used, and I mean that with love. It was one of those bills that you were passively watching because it touched a lot of things. It had some compliance requirements that you really weren't 100% sure on. And then COVID happened, and it truly opened my eyes on why this is an important thing for Georgia, why it's an important thing for me, why it's an important thing for my members. And so that's why I'm here. And we support this from 3 different perspectives. We support it from our member perspective. For anybody who physically cannot get into a branch, this is huge. If you are mentally not capable of going into a branch, if you are serving the military and you cannot go into a branch, this would make life easier because you still have financial transactions that have to happen. Life still happens. So the remote online notary would be huge. We view this and support it from our member capacity. This would have been, and I view this from a very narrow perspective, but this would have been huge to have in law, confirmed, no questions about the validity of the title with COVID. And it would have helped us protect our employees that much more. And it would have helped us not have a weird line through our drive-through with people trying to get items notarized. And then it helps us, and we support this from our credit union. This would help us compete. We have members in every single county of Georgia. We do not have branches in every single county of Georgia. We view this as something that would be positive for us in the years ahead. And I view it a lot like how we listen to music. From a bill perspective, I think we're looking at a bill now where you have streaming in half the house, and then the back of the house, I think the analogy I used earlier was your dual cassette tape track. You know, you're cranking along back there. I just asked for the committee to please move this idea forward because it really is a positive thing for Georgia.
Thank
and
you,
I
Ms.
thank
Bickle.
the committee.
Any questions for Ms. Bickle? Thank you. Next person signed up to speak is Sydney, is it Rubin? With Georgia Credit Union Association.
Yes, sir. That's me. Good morning, Mr. Chairman and members of the Judiciary Committee. I'm very appreciative of the opportunity to speak in front of all of you today regarding House Bill 334. My name is Sydney Rubin, and I'm here on behalf of the Georgia Credit Union. GCUA represents over 2 million credit union members in Georgia. We are elated to see the pursuit of remote online notarization made permanent in Georgia and believe that Georgia should be added to the list of 30 states who have already enacted permanent RON laws. Credit unions are not-for-profit financial institutions that must embrace operational efficiencies to give our members the best possible service. A permanent RON law would provide credit unions a boost of efficiency that will translate directly to benefits for Georgia consumers. An immense amount of work has gone into this over the last year and then some due to the bill sponsor's leadership, bringing countless stakeholders across various industries to finalize a language that passed the House almost unanimously. For these reasons, we encourage members of the committee to support this legislation as it was presented. And again, I thank you all very much for your time on this issue. I know a lot of effort has gone into this and just appreciate your time today.
Thank you, Mr. Rubin. Any questions for her? Thank you. Next person signed up to speak is Mark Holloman with the Superior Court Clerks. Good morning.
Good morning, Mr. Chairman. This is Mike Holloman with the Superior Court Clerks. About 30 years ago, we began digitizing internally the office of the clerk by requiring in statute that each clerk have an automated case management system. Over the last 10 or 15 years, we've begun to spread that idea to the filing of documents external into our office with the objective of fully digitizing the court office, and we've pretty much accomplished that. So the idea of a remote electronic notary is conceptually in line with that effort that we've been doing for literally 3 decades. But more importantly to the bill that Representative Gullett brought to you, we didn't ask him to drop this bill, but shortly after he did, he approached us and asked for our expertise because we do notaries and we do all of that with the authority and both with the clerks in every county. We found out very quickly that there were a lot of dangers to clerks in this bill in terms of liability, both for the authority, which is being basically charged with making this happen. And we didn't want a public relations liability nor a legal liability. This bill, and Representative Gullett mentioned hundreds of hours, we were present and participated in every one of those hours. The bill does accomplish the protections that we've sought, so not really understanding the underlying bill, we're not part of that bigger discussion, but the bill as brought to you from the House meets those needs, and we are hopeful that we can continue that. But we do support the bill as originally brought to you.
All right, thank you. Any questions, Mr. Holloman? All right, thank you. Our last person signed up to speak is Ms. Christine Hayes with the Georgia State Bar. y'all were all setting the standard for our future witnesses. I hadn't cut anybody off yet. I appreciate y'all being so respectful.
Mr. Chairman, members of the committee, good morning. My name is Christine Hayes, and I am the Director of Governmental Affairs for the State Bar of Georgia. The State Bar and its various sections have been working with Representative Gullett and other stakeholders on this remote notary legislation since September of 2019. Its concept has been codified in a number of states, and many of the provisions in the bill in front of you today come from model legislation that was a joint effort between the American Land Title Association and the Mortgage Bankers Association. The concept of remote online notarization was developed with real estate transactions at the forefront of the conversation. Even before Representative Gullett began working on this bill in 2019, the concept was brought to our attention by the State Bar's Real Property section because it was a trend practitioners were seeing adopted throughout the country. When we initially began working on the bill, permitting remote online notarization was a practical and convenient way to modernize the execution of legal documents in our increasingly electronic world. But on March 13th of last year, as our state began to shut down due to the COVID-19 pandemic, the demand for this type of remote technology among legal professionals became more apparent than ever. About 10 days into the state of emergency last March, the governor's office reached out to myself and then State Bar President Darrell Sutton because they had received a number of requests from real estate attorneys who were trying to get the governor to issue an executive order that would permit remote closings by suspending the in-person notary requirement. As we began to work with the governor's office on the executive order, the demand increased and several closing attorneys were very vocally pleaded that the order needed to be issued by March 31st so they could remotely close transactions by the end of the month and the conclusion of the first quarter of 2020. On March 31st, a standalone executive order was issued on remote real estate closings. This was separate from a much more comprehensive executive order issued 9 days later that suspended in-person notarization and witnessing for a longer list of other legal documents. At the same time, the Real Property section requested that the State Bar's General Counsel ask the Georgia Supreme Court to issue an emergency order permitting remote closings under the rules of professional conduct. The court's order was issued on March 27th ahead of the executive order on March 31st. So this is to say remote closings were in very high demand in real estate circles a year ago. The executive order permitting remote closings has been used by some of the very people who have been very vocal about not seeing a statutory framework enacted. Having this bill in place on March 12th of last year would have seamlessly allowed
Hayes, I'll let you wrap up in another 30 seconds if you can.
Sorry.
Sorry. I spoke too soon. Just giving you a hard time.
Okay.
I'm a member of the bar, so I respect your testimony.
Zing. All right.
As I take another 30 seconds with commentary, go ahead.
Sure. So this would have been useful on March 12th of last year. The as-filed version of this bill, we did, like Representative Gullett indicated, a provision was added in the House that would have required a Georgia RON to execute a real estate document. We did raise the issue that this would create title problems under the Gordon progeny of cases. The language was after that taken out because of the title concerns that came up. I'm happy to answer any questions that this committee might have about UPL, the unauthorized practice of law, how the bar pursues and investigates UPL in the state of Georgia, and how the rules of professional conduct play into attorney closings in this state. And in the interest of time, I will limit my testimony.
Thank you. Any questions for Ms. Hayes? All right, thank you. Oh, we do have a question. Senator Kirkpatrick.
I'm going to follow up on the question that Senator Parent was trying to get an answer to previously. Why do we need people outside the United States to participate in this process?
The language, I believe, was taken out of one of the model acts that was from the MBA, the Mortgage Bankers Association, and the American Land Title Association Model Act, and that's why it's in there. Besides that, it's taken out of the model bill.
All right.
And can I briefly mention the reason that wills are excluded in here is like it was mentioned, we don't allow for e-wills in the state of Georgia, and there would have to be a more comprehensive revision to the probate laws and the law of wills in the state if we were to include that in this bill.
All right, thank you. I'll ask the author to come back up. I'll give you the last word. My question for you I'd like for you to address, though, as you've been presented with the substitute that you, I think, are not in favor of, and by the testimony of the witnesses, they're testifying for the underlying bill mostly.
Right.
Is your request that this committee still move the substitute versus taking no action today on the bill?
Yeah, I'd prefer something to move. I prefer my version to move, but if it's a substitute, then yes. something to move, please. One thing I would say is, to answer that question too, it comes from the Uniform Law Commission who created that. So it is part of Model Acts, but it's also part of the bigger Model Act. And so us recognizing other states is part of the fair, faith, and credit clause of why we recognize other notaries happening. And the Uniform Law Commission, that comes from that, why we recognize other places. But yes, I do prefer that we go forward. This does offer UPL, which I think is an important piece to closing attorneys. This is an optional thing. If you're a closing attorney, you don't like it, you don't have to use it. That's perfectly fine. And the attorney is still the driver of closings in Georgia. That's the way our state law is. This does not change that. But appreciate all the testimony for and against, and I'm looking forward to moving something forward.
All right, thank you.
I'll say anything if you don't want me to, Mr. Chairman.
You can have 1 minute to close, Senator. I'd like a motion from you at the appropriate time.
Thank you, Mr. Chairman. I just want to address a couple of things. One, I heard some testimony here that Georgia would be the only state with this exception. Georgia would be that's not exactly accurate. We would be the only state that passed a RON bill, a remote online notary, to have this exception. But no attorney states in the entire union have passed a remote online notary bill yet. And we are an attorney closing state, not a title closing state. Also, I think it was said in some of the later testimony that wills are exempted because we don't allow e-wills. We also don't allow e-closings. This bill allows e-closings. If we were going to allow e-closings, then we should have included and done e-wills as well. Thank you, Mr. Chairman, and I'll make a motion at the appropriate time.
Now would be the time.
Mr. Chairman, I'd ask that we move due pass on LC 413158S.
Second.
We have a motion to pass by committee substitute LC 413158S by Senator Tillery, a second by Senator Cowsert. Do we have any discussion? All those in, we do have discussion. Senator Watson. Wait, well, which mic are you? You're 10?
Yeah. Which one are we, is this as Representative Gullett's? Make sure we're clear on
No,
this.
the motion's been made on the substitute that was brought by
Substitute
Senator
that was
Tillery.
brought. Okay, I just want to be clear. Thank you.
It's LC 413158S. The author has asked us to take action on the bill so that it can move forward. Is that correct? Okay. Any other discussion? Senator Cowsert.
I just want to briefly say I've been kind of quiet during this. It seems to me that the goal of notarization of signatures is to verify that it's the actual person's signature. That's why we require a witness and not just any John, Joe, or Jill on the street. It's got to be somebody that's licensed as a notary that we know takes that duty seriously, because these are legal documents that impact big life decisions. We've talked about wills, transferring property. I think that verification of signature protects individuals from their property being transferred without them signing and agreeing to it, but it also protects the lenders. You may not be happy one day if somebody satisfies a security deed, canceling your loan and your enforcement abilities by a signature that was not, legit in any way. Y'all mentioned you spent hundreds of hours of work in the House working over the past. Well, we've spent 30 to 45 minutes on it here. So when I see things this significant coming through, I put the brakes on a little bit unless it has this great urgency. And as I read things, with the emergency powers of the governor having already temporarily waived the notarization requirements or amended them, whatever he's done there, the crisis, we're okay, to do it. And once this pandemic ends, then we have time to more deliberately decide if, with the technology changes going forward, we're willing to do that. So that's why I support the amendment, which I think sort of carves out some of the pieces. But as I read the law, the emergency orders the governor has in place will remain in effect as long as we're under a state of emergency. So that's my explanation for this.
All right. We have motion on the floor and a second. All those in favor of the motion by Senator Tillery, please raise your hand. We have 4, 5 in favor. All those opposed? We have 4 against, so the motion carries. Who's going to carry the bill in the Senate?
Now that we have a sub, I need to confirm.
Okay, just report back to me this afternoon if you can, so we can get this submitted so you can be in rules.
Absolutely. Thank you, members of the committee.
Thank you. going to go back to cover some bills that we've already had hearings on now. And so on the following bills, I'm going to have the author still come up, but we're going to jump right into testimony. And I will give the author a chance to still close a bill out, unless you have a new sub, and I'll have you briefly tell us what's in the new sub. Next bill is House Bill 327. And we are still working on the same bill that we had in committee on Monday. Is that correct? 327. And so it's LC 280323S. Representative, I'm going to go ahead and jump into the testimony, then I'll have you come up and close if you're good with that. We were in the middle of testimony on this bill when we had to stop earlier this week. Stay close by, though. I'm going to start with, is it Juliano Uber? Am I saying that name correctly? Yes, sir.
Good morning, Mr. Chairman and members of the committee. My name is Nick Giuliano. I'm with Impact Public Affairs. Our firm represents Uber and Uber Eats.
I'm sorry, I really messed that up, didn't I?
I think my handwriting was probably a little misleading. My apologies.
Uber's not named after you, I guess. Thank you, Mr. Giuliano.
So we had a client who was supposed to be here this morning. Unfortunately, he ran into some child care issues. So I'll just briefly state that in the substitute that is before y'all this morning, Section 3 contains a definition, a very broad definition of online marketplace that we feel inadvertently loops in services like Uber Eats and DoorDash and Grubhub and those companies, which we don't believe was the intention of that section. But with the insertion of that definition, we'd like a little bit more time to discuss that and vet that out. In a little bit, y'all will be hearing from a gentleman with TechNet, which is an industry association representing many of those delivery services. He's going to be testifying via phone. So we appreciate some extra time being spent looking at that issue. Thank you very much, Mr. Chairman.
Any questions for Mr. Juliano? All right, thank you. Next person signed up to speak is Brian Hudson on behalf of Home Depot.
Mr. Chairman, thank you, members of the committee. Thank you for, first of all, I want to thank you for allowing Scott Glenn with Home Depot to speak the other day. Scott is our VP of Asset Protection, and I am here, on behalf of the Home Depot, as well as HP. So I just want to stand and just kind of reiterate a few things that Mr. Glenn mentioned the other day. The urgency of this. Home Depot has more than 29,000 associates in Georgia and growing. We have 115 facilities across the state and many of y'all's districts, and we continue to invest in Georgia. And as Mr. Glenn said the other day, a number of proprietary brands, Husky, for example, and usually when you see them on a marketplace, they're either obtained through a store that's been damaged by a hurricane or a tornado, or they're stolen. And a lot of times they're stolen, especially if you see one of 400 available on certain platforms. That's very concerning to us because these are organized efforts that are coming together and hiring out different folks to steal from our different stores across jurisdictions. So this bill does a number of different things, and we're speaking in favor of the entire legislation. It addresses organized retail crime. It addresses gift card fraud, which is a growing problem for retailers across the state. And in particular, again, I can only speak for Home Depot. And then obviously the Section 3 piece that was mentioned before is very important to us. And I know this particular provision of the bill is moving in Arkansas right now, and I believe it's moving very fast, and it should pass in Arkansas as just an example. But this is an issue that's similar to the marketplace facilitator. I wish Chairman Tillery was still here because I know that was debated for many, many years in this body as well as the House. And of course, y'all passed that last year, and Governor Kemp signed it. That's an important issue, obviously, as it relates to sales tax collection. And thank you for your support on that. I think that leveled the playing field as it relates to retailers like Home Depot that have a big presence in Georgia. But this also, we think, closes a loophole. Section 3 in particular closes a loophole where merchandise is going more away from the pawn shops where it's being fenced at the pawn shops, and going more to these online marketplaces where in many cases the sellers are anonymous. There's no contact information. They're not being verified. In fact, I know, and I don't want to speak for Uber, obviously, and Nick can obviously correct me if I'm wrong, but I know that Uber goes through and verifies their drivers in a pretty rigorous process, which I know as a user of Uber, I appreciate that. I think we think this is very similar in regard to the fact that we want our customers and Georgians to know who they're buying from, and if they have any problems, they can have some recourse and get in touch with these people. This does not deal with the ability not to use, this does not address and take away the ability of these marketplaces to use like a contact form, which you may hear about a little bit later. That still is allowed and addressed in this legislation in case the personal address is not being offered and personal information is not being offered. So, and one other thing I want to mention, there has been some concerns. I think I've talked to a few of the members of the committee here about personal information, and in the sub that we brought forward, there is specific language that says that if it's a personal home address, then that does not have to be disclosed in a forward setting on these marketplaces. I think as the retail community, thought that was very important, frankly, for the safety of the third-party sellers. If you have a number of things, maybe it's personal items that you're selling that are new, that's the other thing, is this only applies to new and unused products, not used products. So this does not interfere with any of the casual sellers on an eBay network or anything like that. So I just want to say we fully support this legislation. And just real quick, Mr. Chairman, if I may, I also represent HP, and so bringing a little bit different perspective. HP strongly supports this legislation. They have about 2,500 employees in the state of Georgia and a big print facility up in Alpharetta. They're looking at this legislation from a counterfeit perspective. And when I spoke to them a couple days ago, they're seeing an increase on these online marketplaces for inkjet cartridges, where the counterfeit market is continuing to rise on these marketplaces. So I just want to rise and support this legislation from HP as well. So thank you, Mr. Chairman.
Any questions for Mr. Hudson? Senator Parent.
Thank you, Mr. Chairman. With the handmade goods sellers, like at the Etsy's, I know you've made it not a home address, or the bill is...
Correct. Yes, ma'am.
What's the situation with regards to their full name, the individual's full name?
So if I'm correct, and I may need to have Thomas Busey address that, Senator Parent, but I believe there's certain information required to be verified from the marketplace seller that's not forward-facing, and then on the forward-facing information, if it's a cell phone and it's the only cell phone, if the phone number is only a cell phone, you don't have to provide that. And I believe, do you know the answer? If it's okay, Mr. Chairman, if I can ask Thomas Busey to address that. I'm sorry, I just don't.
He's our next speaker. How about this? We have any additional questions of Mr. Hudson, and then I'll have Mr. Busey address that. All right, you can come on up.
Thanks, Mr. Chairman.
Thank you.
Thanks.
Thank you, Mr. Chairman, members of the committee. Thomas Busey, Executive Director of the Georgia Retailers, representing Georgia's over 500,000 retail employees and 50,000 brick-and-mortar retail establishments throughout the state. I'll start by addressing Senator Parent's question, if that's okay with you, Mr. Chairman. The answer to that is the full name would have to be disclosed. But as Mr. Hudson alluded to, if the address is a residential address, then just city, state, and country would be disclosed. If the phone number was their personal primary phone number, then an email, a working email, or an electronic means of communication to that person provided by the marketplace would suffice. Does that answer your question? Yeah. Oh, wonderful. So thank you guys for hearing House Bill 327. This legislation is extremely important to Georgia's retail industry, and we've been working on sections of it for quite a while. This bill essentially does four things, as Mr. Hudson alluded to. It treats merchants purchasing gift cards, unauthorized merchants purchasing gift cards on the secondary market, to the same recording standard that Georgia currently holds pawn shops. That is a key component of restricting refund fraud in the state of Georgia and giving tools to retail investigators and law enforcement to track refund fraud activity. The section, we'll go back to Section 3 in a moment because I think that's where most of the questions are. Section 4, the two things that Section 4 does originally, no-low pleas were to count towards misdemeanor aggregation for specific crimes, specifically shoplifting and refund fraud. A case in the Georgia Supreme Court nullified that. The Clayton County District Attorney had brought that to Prosecuting Attorneys Council a couple of years ago. We thought it was a great idea, wanted to include that in the bill to make no-low pleas for refund fraud and shoplifting count toward misdemeanor aggregation. We also create the offense of organized retail theft, which is kind of a professional retail thief. RICO is the best simple way to think about it, that if you are someone who is directing, financing, planning others to go out and steal for financial gain $224,999.99 of goods over 180 days, then you get charged with a more serious crime, because we're not talking about shoplifting here. We're talking about the bosses that are directing some of our most vulnerable population to commit these crimes. And we're one of the few states in the Southeast that does not have such an offense. And then to Section 3, which is two things. Section 3 is going to, and you're going to hear a lot of things from the opposition on it, but Section 3 does two things, essentially. It protects your constituents, and it protects your constituent retailers in the state of Georgia. That's what it does. It does that by mandating that online marketplaces, the third-party folks who sell over a certain amount on their platform, are who they say they are. They verify that. How do they verify that? With basic business information that any brick and mortar retailer in your district would have to legitimately open up shop. A business tax ID number, name and contact information, all backed up by government IDs. That's it. That's it. And you're going to be hearing how this is onerous, that some of the largest technology companies in the world can't do this. They can't. They submit similar documents to the IRS every year, tax documents, 1099-Ks, for any third-party seller on their platform who sells over 200 transactions and $200,000 worth of goods. And you'll go, well, that's a lot higher than what we're contemplating in this bill. It is. But starting January 1st of next year, that same 1099-K with that basic business information being sent to USRS is $600 worth of transactions in 12 months. We're asking that these folks that sell over a certain amount verify to the marketplace they are who they say they are. The goods we sell in our stores to Georgia consumers, we know from whom we're buying them. Because if we don't, if there's a problem with that product, if they're defective, if the product was counterfeit, if the product was stolen, which would never happen in a brick and mortar retailer, they could come directly to us and we can go directly to that vendor. That's part one of what this is asking to do. The second part is saying that Georgia consumers have the right to know on these platforms from exactly whom they're buying. As we talked about with Senator Parent's question, if that is a small producer, and that, bear in mind, these are new and unused products with a reasonable threshold, 200 transactions or $5,000, that's a fair and significant amount of goods. But if you're just starting your business and you're just hitting that threshold and you're churning along and you're doing it out of your house and you're using your cell phone, that's protected. That's what the bill does.
All right. Thank you, Mr. Boosie. Any questions for him? Thank you.
Thank you, Mr. Chairman.
Next person up to speak is Jay Morgan, speaking on behalf of eBay.
Good morning, Mr. Chairman, members of the committee. Thank you for letting me address some of the issues with regards to House Bill 327. I am Jay Morgan. I represent eBay as well as the American Transaction Processors Coalition, which also supports 30,000 jobs here in Georgia. Both my clients applaud the leadership of the author and the coalition that brings you language to address retail theft and fraud in sections 1 and 2 of the bill. And I want to just say as an aside, I really appreciate the passion of the Retail Association on those issues. But what lies before you is a new House Bill 327. The original House bill also had a Section 3. The House spent over 10 hours in Chairman Burt Reeves' subcommittee trying to address all the unintended consequences of Section 3. In the end, Reeves, a former prosecutor, and the House committee could not do that and passed a bill without those provisions. The House rejected the notion that Georgia should be the first state in the country to regulate e-commerce. The House embraced, as I know this committee does, Georgia's sterling reputation as the best state in the country to do business. You have in your folder a letter from several companies, eBay being one of those, which addresses some of our concerns. I know that there is also a letter from the Technology Association of Georgia expressing some of those same concerns. You know, I've heard it said many times at this microphone that we should not let the perfect become the enemy of the good. Section 3 is not perfect, and it is now the enemy of small business people all over this state who chose to use a platform like eBay or Etsy or over a dozen others to prop up their small business during the pandemic. For many, it was the only way to do business. And as Georgia's sales tax receipts prove, it worked. Section 3 will require small businesses to put personal information on the platform and thus allow contacts off the platform. Once that happens, eBay and every other platform lose the ability to assist law enforcement in retail theft and fraud prevention as we are doing today. Further, it could also mean that Georgia loses the state sales tax revenue when those transactions go off the platform. Some have told you at this microphone that this only affects high-volume sellers. Yet the limits in this new substitute say that that's 200 transactions or 5,000. I'm really not sure where that number comes from. It's very arbitrary. But it breaks down to 4 transactions and $96 a week. So please allow me to remind you that eBay is a pure third-party marketplace. We continue to work with big box retailers to prevent retail theft and fraud. There are no eBay warehouses. We are not a retailer, nor do we compete with our sellers. Our sellers are our lifeblood, and for your information, there are 219,000 of them in Georgia alone. So I can say with some confidence that there are some in each of your districts. And so the point that was made earlier about having to collect information, we will have to collect this information on each one of those 219,000 sellers, whether they're new or used, because the thresholds are blanket, and then that would require us to collect that information so that we would not be cited for being in noncompliance. Our sellers are our lifeblood, so please do not allow Section 3 to disadvantage them and otherwise pick winners and losers in the marketplace. One final point, Mr. Chairman, regarding verification. When this substitute was first shared with us on Friday evening, I'm not sure that they would also know that Walmart would make an announcement that same day. According to Bloomberg News, Walmart has removed rules requiring sellers on its marketplace website to be registered in the United States so that they can tap into China's vast network of manufacturers. This month, the world's largest retailer began opening up its third-party marketplace to foreign sellers who no longer need a U.S. address or business tax identification. This is the problem with this Section 3. It seeks to thread a needle, which I don't believe we're quite there yet. I hope we can get there. We're committed to continuing to work on it in the off season, but it just illustrates how difficult it is to regulate this marketplace in just one state, the state that would be the #1 state in the country to do business. Thank you, Mr. Chairman.
Thank you, Mr. Morgan. Any questions for him? The next person signed up to speak is Servando Esparza with Tech net?
Yeah, Mr. Chairman, that's obviously not me.
Or
but
Mr. Watson?
Nonetheless, I'm without headset, but nonetheless playing the switchboard operator here this morning. So I'm calling Servando right now, sir.
Okay. Are you also going to call James Hines and Mike Shutley, or are they here?
We'll still be here for the switchboard.
Okay.
Servando?
Yes, sir.
He won't be able to read my body language when it's time to wrap up, so we're trying to let him know the testimony. You're trying to keep it within
Servando,
2 minutes.
Can you hear me?
Yes, sir.
Go ahead and introduce yourself, please.
Thank you, Mr. Chairman and members. My name is Servando Esparza, and I'm TechNet's Executive Director for the Southeast. TechNet is a national bipartisan network of tech CEOs and senior executives that promote the growth of the innovation economy by advocating a targeted policy agenda at the federal level and at the 50 state level. I'm here testifying in opposition to the re-added Section 3 in the newest committee substitute to House Bill 327. I say re-added because the House removed Section 3 after extensive discussion, and HB 327 passed the House without it. A version of Section 3 related to online marketplaces included in the newest committee sub were opposed to Part 3 for a couple of reasons, and I won't repeat a lot of what was just said, but one of them is the threshold for high-volume third-party sellers is still going to include a lot of sellers. A seller in Georgia only needs to have 4 sales a week of new or unused consumer goods to potentially qualify as a high-volume third-party seller. Additionally, due to the requirements to verify information within 3 business days of a high-volume third-party seller meeting that threshold, the likely effect is that online marketplaces will have to collect and verify the information for everybody ahead of someone selling things, just to ensure that that information is collected and verified ahead of that trigger that the threshold seeks to sort of place. Another issue is privacy concerns, which is part of the major issues that the committee substitute seeks to address. We just believe that there's Georgia sellers that do not want to compromise personal information in order to continue selling. As I mentioned, this is going to, just because of the threshold in the bill doesn't mean that the likely effect is that just every seller is going to be impacted. And so for anyone that doesn't want to provide that information, they'll be forced to stop listing their products or lose essential revenue. Another concern, it was shared earlier, TechNet represents a number of third-party delivery services. We've heard from them that they have concerns with the new language, that this would include them, inadvertently include them, which has never been part of the conversation on this, and so I want to make sure that that's clarified. They have serious concerns with that. Another topic that is sort of new on this because of the requirements of listing this information on the pages is that it can only complicate customer service interactions and actions like seeking a refund. So the committee substitute requires that contact information is required to be listed, at the very least name, email, in some cases phone number if they have a business phone number. It could lead to interactions between the seller and the customer in which the third-party platform has no record or can't monitor for trust and safety or customer service. So this provides some bad actors the ability to circumvent established anti-fraud systems from online marketplaces. And so with that, it would also not address any issues where a consumer is not pleased with a specific purchase.
All right.
I'll
let you wrap up,
with
Mr.
it, but we still have
Esparza.
a number of issues on the bill.
All right. Any questions for him? All right. Thank you for your testimony.
Did you want one of mine next, Chairman, or somebody else first?
I'm just going in the order on here, so we'll just knock it out while you're there. James Hines, is that one of yours?
Yes, sir.
Okay. With Internet Association?
Yep.
And then next we'll have Mike Shutley with Amazon.
Yep. Thank you.
Feel like we're doing a radio show now or something.
Never knew my job would be this.
We like technology on this committee, as we saw with the previous bill too.
James?
Yes, sir.
Okay, introduce yourself, please.
Yes, my name is James Hines. I am the Director of Southern Region for the Internet Association. We represent 42 of the largest global Internet companies on public policy issues.
Appreciate the opportunity to address Part 3 of the substitute for HB 327. The substitute does not fix two major problems of the bill. The bill is impractical and unworkable with respect to the collection, verification, and disclosure of personal information. And secondly, the bill will harm small businesses and entrepreneurs. With respect to the collection of information, it does require the collection of government-issued ID and business tax identification. The problem with government-issued ID is that 21 million Americans currently lack a government-issued ID, and we believe that this bill would make it impossible for Georgia entrepreneurs who lack ID to sell their goods online. Also, with respect to verification, there is not a handy verification service available for online marketplaces to use to verify government-issued ID or to verify tax identification information. Also, with respect to verification, we're concerned with liability in that there's an annual certification requirement for online marketplaces. And so if sellers do not inform marketplaces about any changes in their status, that marketplaces have the liability for that failure to verify. With respect to the disclosure of personal information, page 7 of the substitute, you do see that the full name and address is required of the seller. And so even if it is just city state, a quick search on whitepages.com or Google will reveal the physical address of a seller. So we have security concerns, particularly in an instance where there's a heated dispute between a buyer and a seller, and you don't want a disgruntled buyer showing up at the seller's physical residence. With respect to the privacy issues that we think that will be discouraging to Georgia sellers, and so one effect in harming small entrepreneurs and businesses in Georgia is that they will just be discouraged.
Mr. Hines, I'll ask you to
in the marketplace.
asking to wrap things up.
Thank you. So we urge you not to vote for Part 3 of the bill. Thank you.
All right, thank you for your testimony. Any questions for Mr. Hines?
I just hung up on him.
Oh, okay.
I'd rather get to the next one quickly, sir.
Is your battery almost dead?
I charged before an hour ago, so yeah, we're
okay.
good. Thank you, Mr. Chairman.
Next, we have Mike Shutley with Amazon. Hanging in there, Dr. Watson? Okay. Looking weak on me.
Mike?
Hello.
Hey, Mike, please go ahead and introduce yourself to the committee.
Hi, yes. Hello. Thanks, Mr. Chairman. My name is Mike Shutley, Senior Manager of Public Policy at Amazon. I just want to say we're proud to say that we've invested $3.2 billion in Georgia since 2010, and we've created more than 21,000 jobs for Georgians. There are also more than 60,000 small and medium business sellers in Georgia growing their businesses with Amazon. Amazon is committed to preventing all forms of fraud and abuse from harming our customers. We have the processes, technology, and teams in place to protect our customers by preventing counterfeits, unsafe products, and otherwise fraudulent activity before it occurs. In 2019 alone, we invested more than $500 million and dedicated 8,000 employees to this effort. We blocked 2.5 million accounts belonging to bad actors before they published a single listing, and stopped more than 6 billion suspected bad listings from being published in our stores. Our seller verification system analyzes hundreds of unique data points to verify a prospective seller's information and identify potential risks, including looking at the seller's IP address to determine whether they are using a private network to hide their location. We also connect with the person one-on-one through live video chat. And once the selling partner is verified, we consistently monitor these accounts and require additional documentation to list certain products. Unfortunately, Section 3 of this committee's substitute will hurt honest small businesses by setting up roadblocks for legitimate sellers. This bill's verification requirements are ineffective and will not stop criminals who, by definition, will ignore the law. However, a legitimate seller would be suspended from conducting business if they are unable to gather the materials required, or if they fail to merely tell Amazon their information has not changed within the bill's stipulated time frame. The seller verification process in this legislation creates more bureaucracy, not more transparency. Additionally, displaying more information like an email address or a phone number of a seller does not help consumers make more informed shopping decisions. Instead, the bill entices consumers to initiate offline, unmonitored communications that could expose them to fraud and abuse. In order to prevent that abuse, Amazon has specifically tailored tools to best protect our customers and selling partners by minimizing unmonitored communications channels. Ultimately, the seller verification requirements in Section 3 of this legislation won't stop bad actors. We believe this bill is not the right approach to fighting organized crime. Thank you for your time.
All right, thank you so much, Mr. Shutley. Does anybody have a question for him? We do have a question from Senator Hatchett.
Thank you, Mr. Chairman. What other states require this right now?
Senator, no other state has this bill requirement right now.
Okay, thank you.
All right, thank you. Any other questions? All right, thank you, Mr. Watson. Thank you, Mr. Shutley. The next person signed up to speak is Glenn Wilkins with Walmart.
Good morning, Mr. Chairman and committee. My name is Glenn Wilkins. I'm Director of Public Affairs and Government Relations for Walmart, and I represent Georgia and Alabama. Since it seems like everyone's been measuring how many employees we have and jobs that we do, I think I'll go ahead and throw that out there as well. We have over 58,000 associates in the state of Georgia. We've spent over $26 billion with suppliers in the state, and over 143,000 supplier jobs have been created in the state of Georgia. So I think Walmart's in a unique position where we have brick and mortar and a marketplace. There's no one else here who has both. What we have found is that we want to be able to serve our customers on the ground when they need something immediately, as well as if they can have something delivered to their home and serve them in that capacity. What we've also found is that they count on us to have reliable third-party vendors and suppliers giving them product to their actual homes for their families. Currently, we do require all of our suppliers to provide their name, address, and phone number to us. That isn't always posted online, but we have that vetting process. We vet every single person that comes through our marketplace. Now, it was brought up that there is a new rule that we have in place where we're not putting it out on the platform for foreign companies that are coming in. We are still vetting them the same way. I don't see how we would have a foreign company come in on our platform where we don't have a point of contact for them at any point where we can get back to them and work with them on a product where we have a concern. So that is something that is new, and that is something that we believe that we can bring great products to our customers as well, whether it's U.S.-based or not. Another point that was already brought up by Brian Hudson with Home Depot is that anyone that is going to be on the platform should have to go through the same kind of requirements that a brick and mortar would. If I was going to be opening up a store anywhere in Georgia, I do have to provide that information, and we think that that's fair as well. We do encourage we do have a lot of small vendors, third party. We can only fit so much product in our stores. I know those who shop at Walmart feel like there is an unlimited amount of product, but we are limited. We have found that by going online, we have the opportunity to get those small vendors who may not be able to fill the need for that shelf space. They can do that online. So example, there's a coffee roaster in Georgia, and he wants to come in and put product on our shelves. If he's not selling out quickly enough, or he sells out and can't replenish quickly enough on that shelf, then he may lose that shelf space. However, if they're online, then they can go ahead and take care of that customer without taking up our shelf space. And that's how we're able to work with our third-party vendors and smaller suppliers as well. There have been quite a few cases, and this is a problem for all grocers. And it's not just about drills being stolen. It's not about vacuums being stolen. It's about things like baby formula being stolen. It's things about over-the-counter drugs that are being stolen, being held in non-climate controlled containers where the chemical compound will then change. And so when a baby gets something that is not the way it was intended to be built, or someone takes an aspirin, or there's makeup that the chemical compound changes and someone applies it to their face, there are negative reactions. This isn't just a Walmart. This just isn't a big box issue. This is a grocer retailer issue. There are quite a few cases, and I've just recently found this. There's a case in Charlotte, North Carolina a week ago, and the headline of it was criminals turned to online marketplace to sell stolen merchandise, right? We all know that's going on. There was a case in Malaysia where they're actually stealing baby formula and selling it online, right? So when we do our vetting, we're making sure that we know who is selling this. We're making sure that they are a reputable company. Forsyth, North Carolina, same thing, baby formula being stolen. I have those links, and I'd be more than happy to share that with you all as well. Just to conclude, we think that this is a very fair bill. We feel that it keeps us all in line. It keeps us all competing at the same level, whether you're online or whether you're brick and mortar.
All right.
Thank
you,
very
Mr.
much.
Wilkins. Any questions for him? Senator Parent?
Thank you, Mr. Chairman. Thank you so much for being with us, Mr. Wilkins. I just wanted to understand a little bit more about the online marketplace. So for the foreign sellers, you have all the information, the contact information,
Correct.
such as laid out in Section 3, but you aren't putting it forward to the public. Can you elaborate on that a little bit? And
I can't. It's because it just happened so recently.
Okay.
I haven't been fully informed.
do you
on
have
that.
any thoughts on that as it relates to how Section 3 lines it out? Because you're sort of saying, hey, everyone needs to have this information,
Right.
or at least the Walmart does.
Right.
But does that mean that there is wiggle room somewhere in there about whether it's out to the entire general public? Or can you just comment?
I honestly don't have any idea about that. What I have noticed, though, online is we always do put the name of the company that is out there, so it's not just an anonymous kind of seller that's out there. But that's something I can look into for you.
Thank you.
So I appreciate it. Thank you.
Any other questions? Thank you.
All right.
That is everyone that signed up to speak on the bill. The author, I'll give you the last word briefly.
Okay. Well, thank you, Mr. Chairman. I'll say that, I agree with everything that Glenn just said. It's all good points. I'd prefer he wear socks with his shoes, but that's, beyond the discussion of this bill. But here's the deal.
You have 30 seconds.
If Walmart decides to, and I've got a few notes, if you'll indulge me just for a moment. Sorry.
Just a moment.
A small indulgence. If Walmart decides to sell the Chinese, this bill's going to regulate them. I mean, they better have a working phone number. We had some commentary from Uber, it said, but I suppose unless Uber's selling their cars that are unused and unopened, I don't think this is going to apply to them, right? I think that's a stretch. I think we see a bunch of people kind of coming in and say, hey, we're going to do this and do that. For the folks that don't have an ID, that are making over 200 sales online, it may be appropriate that you go get identification. I mean, if you're doing that kind of business on the internet. But look, I think we heard it in the testimony, right? You've got words like discourage, disincentivize, stifle, prevent growth. It's disingenuous, okay? People need to know. I mean, if my wife wants to go online and buy the makeup or whatever, she needs to know who she's buying it from, right? I mean, if I'm buying a baby toy or something like that, I want to make sure it's not a knockoff. And if it is, we need to find out the people who just give, my child, I have a 2-year-old, a choking hazard. Well, we got masks from 3M in the middle of a pandemic, that weren't real. They just weren't real. And they were fake masks, putting the public at risk. I think it's said, I hear this all the time, they say, well, how many other states have this bill? Or, has any other state passed this? Well, you don't become the best place to do business by leading from behind, right? We are the best place to do business in the United States for a reason. It's because we're innovators, and I know y'all are too. That being said, I do have an amendment to the bill on behalf of my friends over here at the Georgia Sheriff Association, if I may present that to the committee.
You have a suggestion for an amendment? What's your suggestion for an amendment?
I will just posit that to you. I think line 78.
Line 78?
Yeah, line 78. Move that from a shall to a may. We don't want to tell our law enforcement partners how to do their business.
It seems like an appropriate amendment. I don't think elsewhere in law we make a a law enforcement officer do something, I guess.
No, sir. No, we don't want to start doing that now.
Okay. Any questions for the author? We have a question from Senator Hatchett.
Thank you, Mr. Chairman. Mr. Representative, I like this bill. I like the thought behind the bill. My question is if there would be unintended consequences with this bill, as we are the first. If I live in, or if I'm at eBay or an Amazon, or I know there are other companies like that are online marketplaces, are there ways to filter out Georgia? Because I guess my concern is if we're the only state that would require this, if I'm in Alaska and let's say I don't necessarily target Georgia and I want to sell in California, would this requirement in Georgia then require Amazon or eBay to verify that seller even if they're selling in California because there's no way to filter out Georgia?
Well, I'll say this. I don't think I can answer your whole question because I'm not a computer guru, and I don't know one way or the other. Alaska, it's far away from here. I don't even think we're contiguous with them. We may be, but I don't think we are. So I'll say this. Look, Ricky Bobby's father said, if you're not first, you're last. Okay? Same thing here. We're innovators. Okay? This is a good bill for children, for families.
The best state in the country
medicine.
to do business.
That's right.
Yep.
That's right.
Include
Best
that
state in
one.
the country to do business.
Any other questions from the committee? What's the pleasure of the committee? We have a motion to pass by Senator Watson by committee substitute LC 280323S. Is that the motion? It is. We have a second from Senator Rett. Somebody want to offer an amendment? I'll offer that on line 78, we change the word shall to may. Do we have a second for that amendment?
Second.
We have a second, Senator Calzert. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. Passed unanimously. Now back to the underlying motion. Any discussion on the motion? All those in favor, please raise your hand. We have 6 in favor, all opposed. 2. The motion carries. Who's going to carry the bill in the Senate?
Well, I was working on this bill. We had a companion bill with Senator Albers, and he's passionate about the issue like I am, and I believe he wants to carry it on forward.
All right. Thank you so much.
Thank you, Chairman. Thank you, members of the committee, for y'all's favorable consideration.
Let's take another one of those 2-minute breaks. We'll come back with Senate Bill 272, House Bill 272, and then on deck we'll have House Bill 94. Come back to order with who's here. Don't leave Senator Hatchett. Don't go far. Is it the governor? Oh, the rules chairman. Your roommate. As soon as we gather a quorum again. Senator Gunter pled his case and that his bill had nobody sign up to speak, and it was actually very simple. Famous last words. I told him he could jump ahead of Representative Ballinger, Representative Rich. But we do have to get a quorum again. So House Bill 306.
Oh, that's right. Okay. That's right. I forgot.
So it looks like the version A I gave you, version A I gave you yesterday, without the or two. Yes. So you know, and I probably, you know why I feel like that's important. They know why I feel like that's important. I mean, I don't know if this is just something. I mean, also know the insurance. Also know this is the insurance community today. I'm gonna have a hard time convincing the majority of the committee that what I need about it, but you tell me.
All right, we have a quorum. Sorry. We have a quorum now in the room, so we'll go ahead and let you explain. We had a hearing last time on House Bill 306. We just did not have the proper LC number with us. Will you tell us the difference in this bill versus the bill that we previously passed that Senator Walker carried through our body?
Yes, sir. I want to thank the chairman and members of the committee, and my apologies to Representative Ballinger for jumping ahead, but this should go really quick. This is the virtual shareholder meeting bill. Senate Bill 168 and 306, when originally filed, were virtually identical. Senate Bill 168 has already passed through the House, and I think it's on its way to the governor's desk. The difference is that this bill adds in nonprofits to the bill, and that's basically the difference between the two. And I'll take any questions if you need further explanation of it.
So it just allows nonprofits to do the same thing the other entities that were previously addressed in the bill?
Yes, sir, for their annual meetings, they can hold them virtually.
Do we have any questions for the author? We have a quorum. Now is the appropriate, nobody signed to be heard on this one. Now is the appropriate time, Senator Hatchett.
Thank you, Mr. Chairman. I move do pass.
Motion to pass on House Bill 306. It's LC 413105S. Do we have a second? Second by Senator Parent. The motion by Senator Hatchett. Any discussion on the bill? All those in favor of the motion, please raise your hand. It passes unanimously.
Thank you.
Who's going to carry the bill in the Senate?
Talk to Senator Hatchett.
Senator Hatchett. Okay.
Thank you.
All right, now we'll go back to House Bill 272.
Thank you, Mr. Speaker.
Representative, before we start, I'm going to do the same thing I did with the last bill.
Okay.
I'm going to let people continue to speak on the bill that signed up, and then let you come in and close us out unless
Okay.
there are some
I was
changes.
just going to basically say I'm turning it over to them.
Okay,
so-
perfect. And then
we're
I'll
on the
give
same
you-
page.
I'll give you the last word on the
Okay.
bill. And so we're going to continue the hearing
Thank you.
from earlier this week on House Bill 272, working off LC 480424S. We'll start with Jeff Breedlove with the Georgia Council on Substance Abuse. Good to see you again.
You too, sir. Thank you for earlier. And as I begin, let me take a moment just on behalf of, I know the whole House, to say thank you to you and the committee members and the staff. This has been a busy day, and we thank you for your hard work and dedication for all these issues. I'm Jeff Breedlove here on the Georgia Council on Substance Abuse. I'm a person in long-term recovery, and we enthusiastically support this important piece of legislation, and we thank Representative Ballinger for bringing it. It's a transformational bill that's going to save lives and restore families, and we say that because, you know, young children suffering from addiction are a large percentage of this population that we're talking about. And we know that young brains, there's scientific data that there's so much trauma sometimes in young people's lives, and their brain development is different than adults. And when they come in contact with a situation that requires law enforcement, we believe that they will get the care they need, the medical care they need, not in adult prison, but in the juvenile justice system. And that alone is why we so enthusiastically support this bill, because we think in the long term, that's a smart investment for the taxpayers of Georgia. Because we also know, unfortunately, that there's scientific data that shows that when young people are incarcerated in adult prison, there's study after study that shows they are much more likely to enter a lifetime of repeat offender status. So we just want to, in the interest of time, just say thank you to Representative Ballinger. We stand in solid support of this. We believe it's a pro-community bill. It will save taxpayer dollars. We believe it's a pro-law enforcement bill. It will keep people out of the criminal justice system. And we believe it's a pro-recovery bill that will give young people a chance to get the medical attention they need on the front end and not become another statistic on the back end. And with that, I'll yield the floor.
Thank you, Mr. Breedlove. Any questions for him? Thank you.
Thank you.
Next, we have Judge Peggy Walker. Good morning, Judge.
Good morning. But I want to point out that I am officially retired, which is why 8 a.m. was just fine.
Well, it's still morning, barely, but
I would have already run off for court, but nonetheless, thank you, Representative Ballinger. Thank all of you for your service. But I do want to agree with what has been said. We've known for a while, and I'm here in my individual capacity because the council generally leaves policy decisions on the scope of our jurisdiction to the legislature. So I'm here as an individual speaking about my leadership role in this community, particularly around things like juvenile justice reform. Specifically, we've known from the brain research, and we also know from the work that's been done by the Pew Commission that criminality is increased when we treat our children as criminals. So we've made every effort to focus on treatment and rehabilitation. This is a natural consequence for us to move forward in this way. And what we are looking for is not disrupting young people's lives. What I've seen is that young people get into a scuffle at school. They have issues with tobacco possession, alcohol possession, and then these things result in adult charges for them, even though they are 17 years of age. And the consequences for them puts them on a very negative trajectory. We are very fortunate the courts and my friends here with the Department of Juvenile Justice take treatment and rehabilitation very seriously. Our role is health, safety, and well-being, and this moves us away from moving our young people further into the justice system, into moving them into education and employment. Thank you.
Thank you. Judge Walker, any questions for her? Thank you. Next, we have J. Tom Morgan. It says Gactyl and author. Good morning.
Good morning, Chairman Strickland. I'm J. Tom Morgan. Was a prosecutor in DeKalb County for 25 years, the elected district attorney the last 12. For the past 15 years, I have been primarily a criminal defense attorney. The last 6 years, though, I'm a full-time professor at Western Carolina University, where I teach criminal law, criminal procedure, and legal ethics. I am the author of the book, which you've seen before you, Ignorance is No Defense, A Teenager's Guide to Georgia Law. Let me just illustrate the importance of this bill with two cases. If you're leaving here and you're going up to where I live up in North Carolina, you'll go through Clayton, Georgia, you'll pass a Walmart. 26 miles later in Franklin, North Carolina, you'll pass a Walmart. If we got two 17-year-olds, one in Clayton and one in Franklin, who are arrested for shoplifting, the young woman in Franklin, the sheriff's office will call her parents. She will be released to her parents. She will be given a citation, and she will show up in juvenile court. There in juvenile court, where juvenile court, as Judge Walker says, they practice restorative justice. She will have to pay a fine. She'll be on probation, but she'll be monitored by the juvenile court authorities. When she finishes, she will not have a criminal record. When she applies for college at Western Carolina or Chapel Hill, she can honestly say she's never been arrested for a crime. When she applies for med school or for a job or technical school, she can honestly say she's never been arrested for a crime. We go back to Georgia, though, to the 17-year-old. Unfortunately for her, her parents chose to raise her in the state of Georgia because there are only 3 states in the United States of America that mandate that every 17-year-old be prosecuted as an adult: Georgia, Louisiana, and Wisconsin. She will be taken into custody by the police. She will be booked in. She will have to get a bond. She will be photographed. She will be fingerprinted. Her photograph will be available. Her arrest will be available. She will not go to juvenile court. She will go to adult court. When even if she's given an expungement, if she's given a diversion program, when she is asked whether or not you have ever been arrested for a crime in any type of application, she has to check yes. Georgia teenagers have to compete with teenagers all across the country. They have to compete for college, they have to compete for grad school, they have to compete for jobs. And in 47 states, those teenagers who make a stupid decision their 17th of life, it will not impact them as it will the students in the state of Georgia. This bill is important, and thank you, Representative Ballinger, for carrying this forward for Georgia teenagers. And let me just say, last year I filed an open records request with the GBI. There were 13,000 17-year-olds arrested in Georgia. 10,700 of them were for misdemeanors. So this will not have a real impact on the juvenile justice system except putting these kids in juvenile court where they belong.
Thank you, Mr. Morgan. Any questions for him?
Thank you for this.
Yeah, thank you.
I'm very excited to have it.
Next, we'll have Dwayne Orick, with the Georgia Association of Chiefs of Police.
Morning, Mr. Chairman.
Morning.
My name is Dwayne Orick. I'm with the Georgia Police Chiefs Association. I'm the assistant director. I served 23 years as a police chief in South Georgia and as Roswell as well. As we get started, I want to note that Representative Ballinger is my representative, and I appreciate everything she's done for our district, and she's, as we all know, very energetic and passionate about what she does. And I also want to thank Tyrone Oliver. He has done an exceptional job with DJJ, and I worked there for 2 years, and I'm going to relate to that in just a second. But currently, the Georgia Association Chiefs of Police are opposed to this bill, and we'll talk about that in just a second. But if it does pass, we ask that it be amended to allow us to be on the actual committee instead of advisors, along with the sheriffs, our partners on this bill. Mr. Morgan spoke just a minute ago, and in 2019 and 2020, there were 13,320 people who were 17 years of age who were arrested and were transported to the jail. So now those won't necessarily be just released. Some of them will be still have to go to an RYDC. Those decisions are made by the juvenile justice officials, not the police officers. Many departments right now are being understaffed, and agencies sometimes have to carry persons as far as 3 to 4 jurisdictions away. Many of our agencies are now reporting, because of all the mass efforts that's going on across the state, they're having much more reduced than ever before, and applicants, and having difficulty fulfilling those. So that's going to leave our streets even more unprotected if we have to add these in there. We're really concerned because I worked at DJJ for 2 years, and whether they currently have the capacity in their facilities and the staffing to make this transition at this time. They're dedicated staff, and they're hardworking, and it's an unforgiving position for what they're doing. The majority of my experience and over the years as being a police officer is most times juveniles are released automatically. They don't go to the facilities. My personal experience, what I'm concerned with is when I started in 1978, between there and 1983, working in the sheriff's department in Middle Georgia, I only recall two juvenile complaint forms being written by a deputy in 5 years. 10 years later, in 1990, I'm a police chief in Cordell, and officers were writing 4 to 5 a day. What happened between 1985 and 1990 in our communities that we suddenly have such an increase in crime? I don't think people's brain quit developing between 1985 and 99. There are other intervening variables that are affecting what's happening in our communities other than brain development. When I worked in the facilities, I would see these older kids that were being put in there, 18 years old, 17 years old. They were being idolized by the smaller kids. They would influence them. They don't cause as much problem because they get other kids to go do their stuff. They call them crash dummies, and have them assault staff, assault other kids that don't fit people, and they're a bad influence on those other children. When I was at Metro, I had 4 officers sent to the hospital with broken bones in 1 year by staff, by youth. We have a numerous number of kids who are out there involved in violent crimes, and I'm very, very concerned for what's happening today. I think if we allow this, it's going to be able to use this as a greater tool to mandate it. As a police chief in South Georgia, we had a 17-year-old that came and was doing some work there. He was outside an event one night and shot somebody in the head and killed him. We had him in custody. We were talking to him. He admitted it, and he was sitting there laughing about it, saying, I'm a juvie. You can't do anything to me. He was from Florida. And then he got serious when we told him, you're in Georgia. You're an adult now. He suddenly started taking the bill seriously. I know that there's issues out there.
I'll let you close it out.
I will close it out. Thank you very much. But I am very concerned about this. Just this past week, we had a 16-year-old who was charged with her second offense of murder. And she was still in holding for the first one when she got charged with the second. And they don't know how many other cases she may have been involved in. The children that are going to the YDCs and the RYDCs are not the kids that got caught with tobacco. And in most cases, these cases are being dismissed. And what Mr. Morgan said, when the cases are expunged, the only people who can see that record is not the university or the college. And their attorneys are being told that, okay, because I had a relative who was arrested and got their case expunged. And they said, if you're ever asked, you tell them you were not arrested unless asked by a police officer. Those records are not accessible to anybody else but a police officer.
All right, thank you, Mr. Orrick. Any questions for him? Thank you. Oh, we do have a question. Senator Hatchett.
I'm sorry.
Yes, sir.
Thank you, Mr. Chairman. I'll tell you, this bill in particular, I've got a pretty large geographical district, and I've heard from every single sheriff in my district in opposition to this bill. And one of the reasons why is due to the fact that they feel they don't have the funding or the resources to make this change. And that goes back to transportation cost from taking a minor from Habersham County or from Towns County to an RYDC facility. And I guess my question to you is, do you agree with that statement that as written, if this change went into effect, that sheriff's departments would be, or police departments would not have the resources right now to make this change?
I agree. And when I was in Cordele, they built an RYDC there in Cordele, but for probably 18 years, when we arrested a juvenile, we had to drive them to Eastman. That's about an hour and 15-minute drive one way. So you were losing an officer 2 to 3 hours just to go transport someone for detention, and then the sheriff had to go back the next morning, pick them up, and bring them back to court. And that is a huge burden on that. And so, yes, sir.
Thank you.
Another issue you need to recognize too is our smaller agencies make up a majority portion of our across the state, particularly when you get outside the metro area. With the 2020 census, there were 30 some odd counties with fewer people they had in the 1930 census. We anticipate that number to have even grown and when the data comes for the 2020 census, the previous 2010 census, but that number is going to go, and what we're seeing is a lot of these smaller communities are getting smaller and smaller and smaller, and so that's going to push a bigger burden if some of these police departments go out of business on the sheriffs.
Senator Rhett.
I was listening to what they were talking about, and thank you, Mr. Chairman, about transportation costs. Would it be possible to add a line or amendment that might state that the department shall reimburse the sheriffs for reasonable and customary transportation costs to try and offset the transportation cost burden that they were talking about?
Obviously, you can offer an amendment. The only thing I would suggest, another option would be to delay when this law will become effective. In doing so, you would allow the implementation committee that's set up under this bill to address certain things such as that. If you also were to delay this, where we would have another session, we'd go through another budget cycle, we would have a chance as a legislature to look at possible unintended consequences that we would see with the law as well. That may be another suggestion.
I'm open for suggestions. I was just thinking about trying to help with the cost that might be inferred.
Yeah. Senator Kirkpatrick.
Thank you, Mr. Chair. I just wanted to let Senator Rhett know that I am planning to offer an amendment to delay the implementation date to give everyone a chance to prepare for this, and that will give us another budget cycle to go through.
Any other questions for Mr. Orrick? Thank you.
Sir. Thank you.
Next person on the list is Deborah Nesbitt with ACCG. Good morning.
Good morning. Thank you. Thank you, Mr. Chairman and members of the committee. As I've said before, we're not opposed to the policy of the 17-year-olds. What we're concerned about is the funding. You know, we heard a lot about there's been funding made available every year for juvenile courts and those kinds of things. Well, when the juvenile code rewrite passed in 2014, we were promised that we would get a prosecutor and a public defender in every circuit in the state. It's now 2021, and we're still 4 short for prosecutors, and I think it's 6 or 8 for public defenders. So my question to you is, when we implement this, are we going to have to wait 7 years to get any funding that's needed to be made available? I have asked on numerous occasions to have a fiscal note done for the cost to locals, and there is a statute, 28548, that requires, if it's going to be an aggregate amount of $5 million or more statewide for locals, that there has to be a fiscal note done by the committee in which the bill was introduced. You can waive that requirement by a majority in the House or the Senate. There has been no fiscal note done for the locals. I think that we'll be looking at $5 million in just transport cost. There was $5 million that was put in a grant program for best practices juvenile programs back when the juvenile code rewrite went through. That money has not been increased. Over the years, it stayed about the same. Most of that money goes to the larger metro counties. And where the cost is going to occur is going to be out in the more rural areas that have to transport those kids long distances and then take them back to court the next day. And additionally, there are a lot of these kids are going to be CHINS kids, and there are no resources at the local level to provide programming for them. So again, we are opposed to the bill because of the funding. And I know a delayed implementation date may give the state time to fund something through the budget, but I will say the only organization that was left off that implementation committee were the county commissioners who pay for everything. So, you know, if there's going to be an implementation committee and if there's going to be cost to the locals, then you should have some local representation. And not completely bypass the funder. Right now, we're funding probably in excess of 70% of the juvenile courts now. And so this is just going to put more cost on the locals without any state funding, or, you know, or a grant is not sustainable. You cannot count on a grant from year to year to take care of your operating cost. So with that, I appreciate the work that Representative Ballinger has done. I know she's very passionate about this. And again, we're not saying that it doesn't need to be done. We're just saying the state needs to fund it.
Thank you. Any questions for Ms. Nesbitt? All right, thank you.
Thank you.
Next person on the list is Jill Travis with Georgia Association of Criminal Defense Lawyers. Still say good morning.
I was just going to say, is
I'm
it still
gonna keep saying
morning? Good morning, Mr. Chairman and members of the Judiciary Committee. Thank you so much for giving me a moment to speak. This is an issue that the Georgia Association of Criminal Defense Lawyers is very passionate about. This has been an issue that the legislature has taken up for years, and we feel like it's time to make Georgia not come in last. We're 47th right now. We don't want to be the last state to treat 17-year-olds as adults. I mean, as children, as they are being treated now as adults. What's the difference? Statistically, 34% of 17-year-olds who are treated in juvenile court are less likely to reoffend. Isn't that really what we're interested in? Don't we want to make this a better society in the long run? This issue of costs can be seen in two ways. Obviously, there could be transportation costs, but there's also societal costs and the long-term effects. This bill, one of the things that I think has been a big misunderstanding about this bill is this is not going to change anything about the kids that you are afraid of. The kids that you are afraid of, the ones that do the 440 cases, the ones that are charged with more heinous felonies, are going to be treated exactly the same. What this bill will do is it will change how you treat the shoplifters and the many misdemeanors. There are lower level felonies that could be treated under this rubric, but by and far, it's the lower level kids that are 17 years old that won't come away with a record. The bill promotes public safety. It uses best practices for children that are proven effective to reduce recidivism. And when you arrested a 17-year-old now, Mr. Morgan took you through the process. When you arrest a 16-year-old for a crime, there's an intake officer, there's a scoring, there's an assessment that determines, does that child go home to his parents or does that child get taken into custody? And this idea that all the kids that are going to get arrested are going to be taken into custody and having to be driven somewhere exaggerates what the actual effect is going to be. So we urge your positive reporting. We are fully in support of a delayed effective date and in terms of the composition of the committee, I think that the idea that I've understood from Chairman Ballinger from the outset is she's going to invite everybody to the table that needs to be there.
All right.
Thank you.
Ms. Travis. Any questions for Ms. Travis? All right. Thank you. Next, we have Terry Norris with the Georgia Sheriff's Association.
Thank you, Mr. Chairman, members of the committee. I'm Terry Norris. I'm Executive Director of the Georgia Sheriff's Association. I'm not here today to talk about the policy change in 272. I am here to talk to you today about the implications for your local sheriff. Some of you may know your sheriff and have heard from your sheriff, and frankly, that's my fault. Blame me or credit me. This is an important issue. This morning, you all addressed the matter of mental health and the transportation of those who are involuntarily committed for evaluative purposes. In 2016, sheriff's offices conducted over 20,000 transports of those people, ill people who needed to be somewhere besides in a patrol car. This particular bill, the sheriff's 272, I should say, the sheriffs ask that you reject this bill. They ask that you study this bill, create some sort of mechanism to study it going forward, not an implementation bill, not a delayed implementation. Because delayed implementation only means in 1 year or 2 years, we will still be deficit of officers. We can't hire people in this environment we live in today. We're down in virtually every sheriff's office in the state. And as Chief Orrick said earlier, when we remove or use a deputy sheriff or a police officer to transport a juvenile to another jurisdiction, oftentimes far away, we're removing limited resources in that community. So we ask that you reject this bill. We heard Monday from our Commissioner of Juvenile Justice, Commissioner Tyrone Oliver. He said in a very succinct way, very polite way, very professional way, that the state of Georgia does not currently possess the amount of resources necessary to maintain services for an additional population of 17-year-olds. You also heard from Sheriff Andy Hester from Turner County, who's been a deputy sheriff in law enforcement for over 30 years. And you heard from Captain Banks from Houston County, who's done this, worked with juveniles for 40 years. Houston County Sheriff's Office happens to have a juvenile division. Most sheriff's offices don't. Captain Banks mentioned to me the other day that he wondered how many juveniles had, or 17-year-olds had been arrested in Houston County. And what he concluded was that in 2019, there were 170 17-year-olds booked in the Houston County, booked in the Houston County Jail. Of that 170, 107 of them had previous juvenile and or adult charges against them. That's 63% of those people. 2019, I asked our sheriffs to give me a little bit of information about 17-year-olds booked in county jails. 63 counties responded to my inquiry. And in those 63 counties, there were 4,225 arrests of 17-year-olds. The exact group we're expanding to under House Bill 272. Of that number, of that 4,225, 2,419 were misdemeanor offenses, 978 were felony offenses, and there were 828 people arrested, charged with both. That's a lot of folks.
Thank you, Mr. Norris. I'll let you wrap up.
I will. Fast forward to 2020, latest GCIC data. There were 5,206 people arrested for felonies and misdemeanors last year. All of those people were 17-year-old. They could, as a juvenile, if this bill passes, they will be juveniles. They will not go to the county jail. Somebody, if they're arrested and detained, will have to take them to far off locations for RYDCs. So again, the sheriffs cannot support this bill. We appreciate Chairman Ballinger. We've had these conversations. It's not a policy question for them at this point. It is purely a cost question. Sheriffs cannot do this. Thank you, Mr.
Thank you,
Chairman.
Mr. Norris. Any questions for him?
Thank you.
All right, thank you. Next, we have Isabel Otero with SPLC Action Fund.
Thank you, Mr. Chairman and members of the committee. My name is Isabel Otero. I am a policy associate with the SPLC Action Fund here in Atlanta, and we support HB 272, and we thank Representative Ballinger for putting this forward. As many of my colleagues have already stated, throughout the process, Georgia does remain woefully behind on this. So far, 47 states have already passed similar legislation, and much like the repeal of citizens' arrest, this poses just another opportunity for this state to demonstrate its emerging leadership in criminal justice reform. Case studies from other states shows us that this legislation does not, in fact, pose a threat to public safety. In 2010, for example, the Mississippi legislature passed a Raise the Age bill, and there have not been any increases in violence or overcrowding of juvenile facilities since its enactment. The portion of 17-year-olds incarcerated remains relatively steady at 20%. And it's also important to note that the passage of HB 272 will not change Georgia law, allowing youth to commit violent crimes to be tried in adult court. So I really urge this committee to follow the evidence and the research, and not be swayed by hyperbole or hypothetical criminal activity. The evidence really does speak for itself, and we don't think that additional study is necessary, right? There's 47 states already doing this. The research is out there. This is good policy. And there really is a mountain of evidence, right, including the scientific evidence already mentioned here today. And to the point that the two gentlemen before me have made, over-policing and criminalization of certain communities, that's what happened over the last few decades to show an increase in arrests. Ultimately, the impacts on counties and law enforcement reflect a smaller short-term concern and misses the positive long-term implications of this kind of a bill. In general, states that have raised the age see a significant decrease in juvenile crime and recidivism rates. Georgia has already seen a steep decline in 53% in arrests of youth over the last decade, and we can continue that trend. 17-year-olds who are tried to juvenile court are significantly less likely to reoffend. They are, more likely to be responsive to restorative measures and rehabilitation. And we can actually improve outcomes for our young people if we pass bills like this. There are services, including providing education for disabled youth, that are only provided in juvenile facilities and not in criminal facilities for adults that are the focus there is punishment.
Hey, Ms. Otero, I'll let you wrap up.
Yes. So before I go, I did want to clarify some points that were made about the Prison Rape Elimination Act from this past Monday's hearing. So our sister organization, the Southern Poverty Law Center, focuses in part on impact litigation. So for those who you all know, are lawsuits that cover a class of people. We have had lawsuits alongside incarcerated adults and children who are fighting for better conditions. And so to protect children from sexual assault while in custody, PREA establishes a legal responsibility to ensure that youth under the age of 18 who are incarcerated or detained are not in a housing unit where they will have sight, sound, or physical contact with adults who are incarcerated. And so the law is focused on the age of those incarcerated, and it sounds like there's 10,000 kids who are being incarcerated with adults for misdemeanors. And so just really quick, a jail or prison's failure to comply with PREA and protect 17-year-old children. So for example, if a child is raped or attempts suicide after being held in an adult prison or jail, that they fail to protect them, they would be open and exposed to legal penalties. So, teens are more vulnerable to sexual violence. They're 5 times more likely to attempt suicide if they're in adult jails. There's just a whole host of reasons why this is the kind of legislation that makes sense, that's good reform. And it is actually supported by several national groups and leaders in this space. And so we hope that you vote yes for this bill today and pass this out of committee, and thank you.
All right, any questions for Ms. Otero? Thank you very much.
Thank you.
Our last speaker, Commissioner Oliver. And Commissioner, I know you shared with us on Monday. I'll give you a second to close out on this before we hear from the author.
Yeah, thank you, Mr. Chairman and members of the committee. I was going to yield my time to bring up Deputy Commissioner Margaret Kaywood, and Dr. Doyle, who oversees our treatment staff and our behavioral health. I think we heard a lot about behavioral health here today. I just want them to share their perspective on what juvenile justice and what we do here, and appreciate Ms. Kilpatrick saying about the delayed implementation, but I just want to yield my time to them if you know.
All right, we can try to
Yes.
do 2 minutes each.
Absolutely.
So if y'all want to come up, introduce yourself, please.
Thank you. I'm Margaret Kaywood, Deputy Commissioner with the Division of Support Services. I've served DJJ for over 20 years, and we all remember that Georgia was under MOA from 1997 to 2011 with DOJ for the conditions in our juvenile facilities, specifically on mental health education and safety, and we wish not to repeat that. The raise the age desired outcome is rehabilitation. A delayed, phased implementation with thoughtful planning and assuring resources and rehabilitative services are in place in the full continuum from community to secure facilities could assure that that happens. We're concerned about the capacity and the impact on our facilities. Georgia does detention. We have 19 detention centers. Those youth charged with SB 440 would stay in our detention centers until they turn 18, increasing our population, as well as those detained felons with serious felonies. And then once that they are convicted or committed, they would continue to remain with us, impacting our capacity. And then this would also impact our capacity in the community, from the lower risk offenders needing supervision, needing mental health treatment, and residential capacity. And we've already heard the concerns about mental health treatment capacity in the community, and those are concerns of ours. And I'm going to turn it to Dr. Doyle, who will go into the specifics of treatment.
All right, thank you, Dr. Doyle.
Thank you, Mr. Chairman. I am Dr. Christine Doyle. I'm the Director of Behavioral Health for the Department of Juvenile Justice. A lot of folks have mentioned adolescent brain development. I won't belabor that, but I do want to reemphasize that that is a factor. But we've talked a lot about what the kids being served in DJJ facilities need in terms of behavioral health. The code reforms that went into effect January 1, 2014 had the intention of diverting lower risk, lower needs kids out of secure facilities, and it was very successful in that objective. What that means, however, is that the children that we are serving in secure facilities now are high risk, but also very high needs. For example, 50% of the children in our short-term RYDC facilities require ongoing mental health treatment on the mental health caseload. In the YDCs, that number goes up to 70%, and those numbers have been consistent across several years. Roughly 50% of the kids that we serve require substance use treatment, and that's been spoken to earlier today as well. And 30% of the kids in our secure facilities qualify for a full diagnosis of post-traumatic stress disorder. If you look at the Veterans Administration website, they estimate that PTSD rates in returning combat veterans are between 10 and 20%, but our kids are 30%. So the treatment needs of this population are significant, and the need for a trauma-informed, trauma-responsive therapeutic milieu in secure facilities requires appropriate staffing, of security staff to help the kids feel safe enough to engage in treatment, and of treatment staff to provide the evidence-based treatment services that these kids so desperately need. So in order to have the maximal outcomes and return these children to their communities as productive citizens, we do need to have a thoughtful, planful implementation that phases in the necessary resources. Can I answer any questions?
Any questions for Dr. Doyle? Thank you so much for sharing with us today.
Thank you for your time.
That's everyone that signed up to speak. Representative Ballinger, I'll let you briefly close us out.
Okay, I will be very brief. You know, one of the things that I do want to point out is, as we were looking at the numbers, if we were to raise the age, we would be dealing with the exact same numbers because of the decline that we've had in juvenile arrest rates over the last 10 years. We will be dealing with the exact same rates of juveniles that we had in our juvenile system in 2014. So is it impossible for us to say in 2021 we can't do what we said, what we did in I'm sorry, it wasn't 2015, it was 2014. Can't read my own handwriting. So, you know, this is not around the moon. This is not too far a reach for us, and it shouldn't be. No one has contested the policy of raising the age. Everyone has been very sympathetic. Everyone, I think, in this room can agree that we should do this. It is the how we do this that is the question. That's why we have the implementation committee. That's why I've agreed to a pushback of the effective date of this bill. I'm willing to work with partners, sheriff's office, chiefs of police, county commissioners, yada, yada. Nobody has come to me and said, hey, put us on the committee. So that's how the committee got started. That was my best guess. So, you know, nobody has made anything wrong. There's nothing wrong with the policy. 47 other states did it. Alabama did it in 1977. Hey, we're only 43 years behind Alabama. Hello, let's get with it. Yeah, very few times are we offered to do the right thing, just the pure right thing. This is the right thing for our 17-year-olds. We can argue about money, but I think we got sent down here by our constituents to get things done, to make it happen, to make good policy happen. And that's what I hope you'll give me the opportunity to do, is to make this happen. Thank you.
Any questions for the author of the bill? What's the pleasure of the committee?
Mr. Chairman, would you entertain an amendment?
Yeah, let's get it a motion first.
Okay.
We have a motion to pass by Senator Parent. Do we have a second? We have a second by Senator Jones. You recognize for an amendment, Senator Kirkpatrick.
Yeah, thank you, Mr. Chairman. My amendment would be on line 40 to change December 31st of 2021 to 2022. That's for the abolishment of the committee. And then on line 496 to change 2022 to 2023.
All right, we have a motion for an amendment from Senator Kirkpatrick. We have a second from Senator Rhett. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It's unanimous. All right, back to the underlying motion. Any discussion on the bill? All those in favor of, yes, Senator Hatchett for discussion.
Just a little discussion on that amendment. Does that amendment just delay the establishment of the committee, or does that delay the implementation of raising the age to 18?
Senator Kirkpatrick, do you want to address that?
This would delay the implementation date of the whole thing. That's on line 496.
Well, you're doing, so on line 40, you're delaying when the committee will no longer exist. And then on 496, at that point, you are delaying the effective date of the bill itself.
Okay. I just wanted to make sure we got that in there. Thank you.
In essence, you're doing everything a year longer than the original bill had.
Thank you, Mr. Chairman.
Back to the underlying motion. Any other discussion? All those in favor of the motion, please raise your hand. We have 5. All opposed? 3. The motion carries. Who will carry the bill in the Senate? Senator Parent? Okay. Thank you. All right. We are moving along. We're getting there. We're going to go to House Bill 94. Representative Rich. We do have a substitute that's being brought on this bill. And what I'd like to do, we already had a hearing on this. Did we do a sub one? We had the same sub from the last hearing, is that correct? Or is there a new sub? There is a new sub. Okay. And so we're working, give us 1 second, okay. Okay, we're working off LC 413153S. There's no one signed up to speak on this bill, but I would like for you, before we vote on the sub, to explain to us the difference in the bill today versus the bill that we had on Monday.
Yes, thank you, Mr. Chairman and members of the committee. I have worked with some of the senators on this committee to draft some language that I believe ameliorates the concerns that were expressed at the last hearing. If you start on line 27, this is in the first portion of the bill that deals with mail theft. We have added a line that in the discretion of the trial judge, that the crime can be charged as a misdemeanor. And then moving along to line 39, which is in section 2 of the bill and deals with porch piracy, we have added that in order to satisfy the elements of the crime, that there be 3 or more packages. And then line 41 through 42 provides the additional requirement that those packages be from 3 or more different addresses. I will note also on line 41 there appears to be a typo. The second word of, it's after 3, should be or instead of.
Do you also have a typo on line 39 with the word envelopes?
Yes, there is a typo there as well. Envelope should be spelled with an E-S instead of just S.
Okay. Any questions for the author? All right, there's no one else that's signed up to speak on the bill. What's the pleasure of the committee? Senator Kirkpatrick.
Move to pass.
We have a motion to pass by Senator Kirkpatrick. Committee substitute to House Bill 94 LC 413153S. A second by Senator Rhett. Senator Kirkpatrick, would you like to make the 2 amendments? On line 39, adding an E between the P and S on envelopes.
Sure.
And changing the of to or at the end on line 41. The second, excuse me. So it'll read dwelling of 3 or more, changing that of to or.
I'm sorry, which one is
on
that?
line 41.
Yeah. I would make both those amendments. Line 39, add an E in envelopes, and line 41, change of to or. The second of. The third of.
All right, we have an amendment from Senator Kirkpatrick. Do we have a second? We have a second from Senator Parent. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. It passes unanimously. Back to the underlying bill, the underlying motion. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously.
Thank you.
Thank you. Oh, you are here. I was reading your text. The next bill on the agenda is House Bill 194. Representative Saines. Who is Representative Rich? Are you still in the room? We'll need to know who's going to carry. Was somebody in the room going to be carrying that bill? Senator Kennedy, are you carrying House Bill 94 for Representative Rich? Yes, Mr. Okay. Thank you. Always stop me, Beth, when I mess up. All right. 1 second, Representative. We're doing the best we can to keep a quorum, and so we will try to, I think most of the bills we have left will be a little bit quicker than our previous bills, but we'll try to move as quickly as possible. We've already had a hearing on this, Representative, but you are bringing us a substitute. Can you please tell us the changes in the bill?
Sure, and the substitute represents technical updates that actually Senate research, I believe, recommended to the committee. I verified with them that there is no subject-related modifications in the substitute based on what was heard in the hearing. I don't want to give, I don't know if this is something that the committee wants on the technical modifications for Senate research to highlight the changes they recommended. It was just based on, from my understanding.
I'm going to recognize Ms. Vaughn.
Hi, sorry, I usually keep the mic away from me. So very quickly, there were kind of two categories of changes that Senate research flagged from a policy perspective for this substitute. Most of those dealt with the relatively new crime of improper sexual contact by a foster parent. That was passed last year in House Bill 911. That crime is kept in parity for the most part with improper sexual contact by an employee or agent. We did some cleanup in the bill to propose adding in improper sexual contact with a foster parent by a foster parent, just to kind of keep it in line with where we saw that being in the code. We also did a little bit of cleanup from House Bill 911. When the bill was passed last year, the definitions of sexual offense and of dangerous sexual offense were not updated to include improper sexual contact by a foster parent. There was no policy reason for that. It was just an oversight and discussions with the House bill sponsor. It seemed like it was something we could not get amended at the time due to the COVID pandemic, and so the bill passed without those updates. This bill adds improper sexual contact by a foster parent into those two definitions. And then the only other substantive change that we suggested was if you'll look at the substitute LC 413150S, at line 106, we removed the phrase labor or in regards to a second offense related to trafficking for sexual servitude. It included labor or, and the structure of the bill otherwise was focused on sexual felonies. Labor servitude does not have a sexual component, and so we had suggested that that be removed as well. I'm happy to talk in more detail about the changes, but that's the very quick overview.
Any questions from Ms. Vaughn about what she spoke on some changes we made on the substitute? Can you briefly address a couple of typos we discovered in the bill? Do you have that in front of you, Ms. Vaughn?
Yes, I do.
I think it'd be quicker if you want to quickly address those that we can offer as amendments.
So I believe the only other change, in preparing the substitute, Julius Tolbert, who is the legislative counsel assigned to Senate Judiciary Committee, prepared this substitute. In the previous proposed substitute, the definition of sexual felony was in a standalone statute. Julius, who I think is online and can answer questions about this, moved that definition to a subsection of Code Section 16521. And there is a typo at
line 513.
At line 513 in the new proposed substitute, where it says Code Section 16-6-21 has that definition of sexual felony. So that's just one more bit of cleanup. the definition is actually in 16.5-5-21, and at line 513, it says 16.621. So we would need to address a little cleanup there.
Okay. All right. Any questions for the author, Senator Kirkpatrick?
Yes, Representative, thank you. We've had a long conversation back and forth about this bill because I was on the study committee that was trying to address the Supreme Court decision back in 2019. And granted, there were no lawyers on the study committee, so I'm a little bit out of my depth here. But we have had this conversation about whether to change shall to may. And you seem to think that that should not happen. I'd like for you to explain the reasons.
Sure. And just to predate on the subject matters, there seems to be two major sections of the bill that didn't have a lot of questions, which was A, the SOAR procedural changes that would make it a more efficient and effective process for the Sexual Offender Risk Review Board to do their work. And then B, there was some committee testimony, I think, against it, but not as much committee questions on the Edgelson versus State clarification on what constitutes one charge of child pornography when it's not a copy. What you just asked, which would be what I've categorized as the C section, which would create a mechanism to allow GPS monitoring of dangerous sexual offenders. So from that study committee that you were on, and as well as the late Senator Kirk, I addressed a letter to the committee that came in very late last night. I think hopefully y'all have a copy as well, that highlighted the significance of that initial may in each of these sentencing. So again, this concurrent lifelong sentence would only take effect if the offender has committed one of the menu of felony sex crimes listed here. And they're specifically what we did to create that menu was try to work with SORB on what menu creates when it's a recidivist offender, what menu creates the highest likelihood that offender will be then leveled a level 3, which is the top 10% most dangerous sexual offenders in the state. So out of all those who are leveled by SORB, the top 10% on average are leveled to 3. So the Senate Study Committee, which truly did shape this bill, so I appreciate the work of those members, recommended that upon that the judge takes into that SORB account when looking at the possibility of a lifelong sentence. And what we did when we went back, and that was frankly the initial drafting of the bill, we took feedback from SORB that noted that the efficacy of that leveling is much higher upon on their ability to review both their time incarcerated as well as their at least 10 years. Frankly, Michigan, that is noted in the study committee, has 20 years, so we're a little bit more lenient, but at least that 10 years, that data that they collect to level them and re-level them most often is crucial to understand whether that leveling was too high initially or too low initially. So we felt that was a compelling enough case to restrain from the state taking the irrevocable action of giving away our tool that's now restricted by the State v. Williams decision, and holding off and saying if you're twice a recidivist sexual offender for these items, you are statistically 95% likely to be leveled a dangerous sexual predator. We're going to hold off on the judge making the determination, if it's appropriate, 10 years after probation, so that the judge at that point has a SORB leveling with a higher efficacy to make that determination. Does that answer your question?
I'm going to recognize Ms. Vaughn to address one additional typo in the bill.
Oh, sorry. It's one of the changes, and just in the rush, I know we're short on time, I forgot to address this. The bill as it passed the House was focused on improper sexual contact by an employee or agent in the first degree. We added in improper foster parent contact, which I mentioned previously, but there are also felony offenses available under the second degree in relation to offenses against 16-year-olds or someone who has committed that offense twice. They could be sentenced for a felony. And so substitute you have before you now incorporates that felony offense under the first or second degree for all of the versions of improper sexual contact. Sorry. Thank you.
Thank you. And I appreciate you catching some stuff we can do. We're moving these bills to address some of the holes we have in the law. I appreciate your work on that. Ms. Travis has been so kind. She's already testified on the bill, but it's been so kind as to point out a couple other typos that we may want to look at. And so I'm going to recognize her for a minute. It's all hands on deck.
I know it's gone through a lot of drafting on page 1 at line 17 to remove the registration fee. That's no longer part of the bill, so you probably want to strike that. On page 3 at line 63, the language is not underlined in its new text, and it should be.
All right, stop on that. So we should have that entire line underlined?
Yes, sir.
Okay. All right, I'll let you continue. Line 63, it's new text, so it should be underlined in the bill. It's not.
And then, if I might, the testimony seems to be conflicting about this may and the shall. May I comment on?
Briefly?
Yeah, very briefly. For example, statutory rape, second offense, carries 20 years. Now, what this bill would do, it mandates a life sentence, which means the person has to be in custody, in prison, for at least 30 years before they're considered for parole. And then another 10 years before they can consider coming off of monitoring. So I could give many other examples of where you're tying the judge's hands. This really was, if you look at the report from the Senate committee, there is no doubt in my mind that the committee found that there should be discretionary. And so for those reasons, we would ask for the shalls to be changed to may and I can say the line numbers out loud, but I'll ask you to ask me that question if you're interested.
All right. Thank you, Ms. Travis.
Am I excused, sir?
Yes. Thank you, Ms. Travis, and I appreciate your help. Even when your organization is opposed to a bill, I appreciate you still pointing out things we can do to make sure it's written correctly. All right, that's everyone that signed up to speak on the bill. What's the pleasure of the committee? Senator Rhett.
I just want us to maybe reconsider, instead of shall, making it may, when it comes to, help me out, Senator.
Let's do this. Let's get a motion on the bill, and then we could consider amendments at that time. We have a motion to pass by Senator Hatchett by committee substitute LC 413150S. Do we have a second? We have a second by Senator Watson. Are there any amendments? Senator Rhett, would you?
The Senator's helping me out.
Senator Parent, do you want to be recognized?
Sure. I will move to amend. Let me find the bill number. LC 413150S. We would need to, where the bill specifies shall, the amendment would be strike shall and insert may. And I was looking for my document that had the line numbers, and I don't find it easily, so maybe we could have Ms. Travis read off those line numbers.
It may not be that simple. There's two different ways that the bill has shalls versus mays. You have the life sentencing part, and then you also have the portion dealing with electronic monitoring. And I do have a list of all of the lines that Ms. Vaughn provided to us that deal with both issues. And so you have the shall for punishment of life imprisonment or split sentence followed by probation for life on line 65, line 84, line 106, line 117, 126, 138, 149, 160, 174, 184, 194, and 217. You have also the shall and may in consideration in looking at the electronic monitoring itself. And those are that's on line 67, 86, 108, 119, 129, 139, 151, 162, 176, 186, 196, and 219. So the question, I guess, would be on your amendment, are you offering an amendment that would deal with both of those issues or just one or the other?
I would offer the amendment to do it on both of those issues, Mr. Chairman.
Okay. Is everybody clear on what the amendment is? All right, do we have a second on the amendment? So amendment from Senator Parent, a second by Senator Redd. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. 3 opposed. 3, the amendment fails. Any additional amendments? The typos that were mentioned, I will mention again if somebody wants to offer as an amendment. On line 17, remove the registration fee and the semicolon after that. On line 63, to underline the entire line since it is new text being added to the law. And on line 513, instead of code section 16-6-21, it'd be 16-5-21. Did I cover everything? I'll offer that as an amendment as chair. Is there a second? Second by Senator Kirkpatrick. Any discussion? All those in favor of the amendment, please raise your hand. Carries unanimously. Back to the underlying motion. Any additional amendments? Underlying motion on the bill. All those in favor of the motion, please raise your hand. We have 3 opposed. We have 3. The chair votes yes. The amendment carries. The motion carries. Thank you.
Hatchett has agreed to sponsor the legislation on the Senate side. Thank you.
All right. Thank you. Are we almost there? If the committee can hang on just a little bit longer. Thank you. House Bill 231, Representative Gaines. We have already heard this bill as well. You did bring a substitute. If you can briefly tell us about the substitute. There is just one person. One person signed up to speak on this bill. I'll recognize after you tell us the difference in the bill.
Sure. Well, thank you, Mr. Chairman, and appreciate y'all's time on this bill. The changes from the last time we heard it was we removed the minor piece after a lot of conversations with folks, a lot of conversations with everybody involved, advocates, Chairman Burchett in the House as well. So I appreciate y'all's time and work on that. That's something as we move forward this fall and something we can consider moving forward. But in order to make sure we get something done to protect as many victims of domestic violence as we can, we want to go ahead and move this bill forward. The other change was something that came up in Senate committee last week. You know, the question of recently versus putting a specific timeline on it. So on line 32, instead of the word recently, we changed it to within the last 6 months. And so those are the only 2 changes in the bill, Mr. Chairman. And would also ask April Ross, who's the Executive Director of the Commission on Family Violence, is here as well, if there'd be an opportunity for her to briefly speak as well.
Okay, any questions for the author? And are the speakers in favor of the bill that are here? I'll ask Ms. Ross if you want to share anything about it.
Thank you, Mr. Chairman.
You recognize. And then we also have Jamie Borman that signed up as well. I appreciate the work you guys did in getting ahead and hopefully preventing a back and forth between the House and Senate on this. I appreciate the work you did in getting ahead on that. Good afternoon.
Good afternoon. Thank you so much, Mr. Chairman. Just April Ross on behalf of the Georgia Commission on Family Violence. We're just really happy that this bill is moving forward. We think it's very important to protect a very vulnerable population that's been left out of the protective order bills for a long time. And we certainly agree with Representative Gaines and appreciate him for carrying this bill and all the work that's been done on amending it and trying to make it as good as it can be. We welcome the opportunity to continue to work on discussions around some of the other issues in the future, but we believe that this is certainly going to help a very vulnerable population of victims who do not currently have access to protective orders. With that, I know we've already had hearing on this, so if there are any questions for me, I'm happy to entertain.
All right, thank you, Ms. Ross. Anybody have a question for her? Appreciate your work. We also have Jamie Borman. Good afternoon, Ms. Borman.
Good afternoon, Mr. Chairman. Mr. Chairman and members of the committee, thank you for offering me a few minutes to speak today. I'm the Deputy Director for Crisis Line and Safe House of Central Georgia, which is a nonprofit program that provides services to victims of domestic violence and sexual assault in Macon. And I've worked with victims of domestic violence for 15 years, and I'm here today as an advocate for the folks that this bill will benefit. For the last 12 years, I've worked specifically with victims and survivors who are seeking protective order remedies through our superior courts. And I'm here today in support of House Bill 231 because it addresses a significant gap in our law for protections for survivors statewide. Currently, victims in Georgia cannot obtain a protective order under our Family Violence Act if they're not married to, share children with, or cohabitate with their abuser. So we're closing that gap by moving forward House Bill 231, and I'm so thankful to Representative Gaines, Representative Wynn, and the others that have worked really hard on this bill. In my experience in working with victims, in Georgia, a lot of folks who access protective orders do so through their local domestic violence program. And so there are legal advocates from across the state who work with survivors to navigate that process. And so I have worked with folks who have contacted our organization and asked for a protective order who've been assaulted by a partner but don't meet the current criteria under a Family Violence Act. Maybe they are pregnant but they're not married and they don't live with their partner, and so they are turned away from this remedy. And so this is very important. Also, protective orders are a really important tool for survivors to keep themselves safe. Domestic violence victims are in the most danger when they are making plans to leave or have left their abusive partner. And so this offers an opportunity for more folks who are experiencing domestic violence to be protected. And states that have already expanded protective order options to dating violence victims have seen an 11% reduction in the overall domestic violence homicide rate. Victims need access to legal remedies sooner rather than later when experiencing violence in an intimate relationship, not just once they're living with the person or have shared children with them or have been married to them. Advocates want victims of intimate partner violence to have tools to keep themselves safe before the abuse escalates and before the victim has had to commit to some long-term relationship that would qualify them for the order as it stands. So I believe that House Bill 231 is a significant step in offering protections to those very victims. And I thank y'all again for allowing me to speak this morning, and I'm happy to answer any questions.
Thank you, Ms. Borman. Again, I appreciate the work you do as well. Any questions for her? All right, thank you.
Thank you.
I asked the author to step back up. I have two questions for you before we move on the bill. One, well, it's not really a question. You still have the word minor on line 35. I think it's just a typo that should be deleted in the final draft of the bill since we took minors out. And so unless I'm missing something there.
Well, I guess, yeah, nowhere else in the bill are minors referenced, so trying to make sure. I think that would be fine to delete line 35.
The other question I had is just I guess you can clarify for me. Your bill, while it tracks the family violence TPO language, you do not include the misdemeanor offense of criminal trespass, as we see in family violence. Is that on purpose?
That was one conversation that came up in the House committee and process, and that was something that was requested to be removed.
Okay. That's all I have. Any final questions for the author? Senator Kirkpatrick, motion? I had you on. You keep turning it off. Hold on.
Sorry. I would move do pass on House Bill 231.
By committee substitute LC 413151S. Is that correct? Is there a second?
Yes.
Second by Senator Hatchett. Any amendments?
Sure.
Senator Kirkpatrick.
Yeah, so I would move that we strike line 35.
All right, that would just take out the definition of minor that's no longer mentioned in the bill. Is there a second? Second by Senator Hatchett. Any discussion on the amendment? All those in favor of the amendment, please raise your hand. Carries unanimously. Back to the underlying bill, underlying motion. All those in favor of the motion to pass, please raise your hand. Carries unanimously. Who's going to carry the bill in the Senate?
If you're willing, Mr. Chair.
Are you pointing at me? Okay. All right. All day I've avoided that, and I just got tagged with one. That's a good bill. I appreciate it.
Thank you.
All right, y'all have been so patient all day. Representative Leverett. I don't know where you are. There you are. Come on up.
Which would you like to hear?
Let's start with House Bill 411. Excuse me, we already heard that. House Bill 443.
I was going to say I don't think that's my specialty today, Mr. Chairman.
And let me get my notes straight.
Mr. Chairman, what's your preference? Would you like me to retain the mask, or can you hear me through it all right?
Whatever you're comfortable with, as long as those sitting in front of you are comfortable. I think others take it off, so you're fine.
Okay.
We have more space now. If anybody wants to relocate in the committee, they can come up here. And so we are working off of LC 413155S.
Yes, sir.
The floor is yours.
That's correct. Thank you, Mr. Chairman. First of all, I appreciate very much your placing this matter on the agenda, and appreciate the committee's agreeing to hear it. I know it's been a very long day for y'all, and I'm sure you're sort of at the Jerry Clower moment of shoot up in here amongst us. One of us got to have some relief, so I appreciate y'all sticking in here. House Bill 443 would adopt the Structured Settlement Protection Act, which is a uniform act. We already have such an act in Georgia, or a much earlier version of it, and this would update it, modify it, and strengthen it. I believe this act basically allows us to prevent the unscrupulous from taking advantage of the disadvantaged, in effect giving you the ability to cast the wicked money changers from the temple. As you probably know, Mr. Chairman, a structured settlement is just a settlement in which payment is made over time rather than in a lump sum. This bill would not regulate the entering into a structured settlement. It regulates the sale of a structured settlement. And so as a circumstance, after settling a claim in which I am receiving payment over time, I may develop a need for a larger sum of money than the periodic payment. Perhaps I have medical expenses, or if I was injured in the initial claim, perhaps I need to buy a new accessible van, and so I want to convert that right to income in the future into some money right now. And there are companies that will purchase these, either the remaining stream of payments or just a portion of them. And this bill regulates that process, because the people selling them do tend to be in somewhat dire straits. They've had a catastrophic injury, or they've suffered a great loss. Sometimes they're minors who are now leaving their minority, and the process of determining what is a fair price is, as we say in Elbert County, kind of high finance, and so it's easy to take advantage. So this bill proposes to provide additional protections. It takes the existing law, it I think strengthens and makes more robust the disclosures that are required. It still requires that court approval be obtained. That's not being changed. But it does require that the entities who want to purchase or want to buy a structured settlement have to register with the Secretary of State and post a $50,000 bond. This is based on the national, on a uniform act proposed by the National Council of, I believe it's insurance legislators, and it has been adopted in 48 of the 50 states. I think New Hampshire it's like it is here in Georgia. It's pending, and an additional provision is it does have a venue restriction, so it prevents you from taking your Georgia resident and driving to Oklahoma where they have a less stringent provision to get your structured settlement approved. So there's sort of a concern that if we could become a dumping ground if we don't also adopt the act. And I understand New Hampshire is in the process of doing so as well.
All right.
So I believe it's a good bill. It is a rather lengthy one, admittedly, but it was simpler to show it all as one new set rather than go through and tinker with all the existing statutes. This is not a radical change, but it is I think a positive change that's more protective of the consumer.
All right, I appreciate it. Any questions for the author? All right, we have one person signed up to speak on the bill. Amanda, I cannot read. Dobinton. National Association of Settlement Purchasers.
Yes. Hi, Chairman and committee members. Thank you for hearing me today. Yes, good afternoon. It feels like it should be good night at this point, but I am here. I'm a long-term resident of Georgia, and in addition to being a resident, practicing attorney in this state, and I am also a business owner. I am co-owner of a structured settlement purchasing company, a company that would be held to the standards in this statute. We would be required to do bonding registration, file in the county where payees reside, and abide by avoid doing the prohibited acts. We've been in business in Georgia for 14 years. We're one of the only main companies that are purchasing these in the state of Georgia. And in addition to that, I sit as a board member on our National Association of Structured Settlement Purchasers. I've been involved in legislation in other states. The most recent state to pass similar legislation with the prohibited acts and the bonding and registration is Louisiana. That became effective in July and has gone really well and very smoothly in Louisiana. We don't anticipate more than 10 to 15 companies seeking bonding and registration in the state of Georgia. And again, this brings, the last time Georgia updated our act was in 2003, after the Model Act came in 2002. And then the Model Act has since then, almost every 5 years, has been changed, revisited, addressing just issues that we've seen arise within the industry across the nation. And so the last update to the Model Act was 2016. The next update will probably be in the next year or so. And we do believe the next update will also include these prohibited acts as well as bonding and registration in there. And then, of course, the other changes to Georgia's current act are already in the Model Act and will bring us in line with that Model Act. So as a local business, as a resident of Georgia, as a practicing attorney that does these transfers, we are in support of this bill. I've been very hands-on in the drafting of this bill and the forward progression of it. And so just wanted to speak today and answer any questions if you have any.
All right, I appreciate any questions. All right, thank you for your work on this.
Thank you all.
There's no one else that signed up to speak on the bill. What's the pleasure of the committee? We have a motion to pass by Senator Parent. Do we have a second? Second by Senator Jones. Any discussion? All those in favor of the bill, please raise your hand. It carries unanimously.
Thank you, Mr. Chairman.
Who's going to carry the bill in the Senate?
I believe Senator Hickman.
Senator Hickman. Okay.
Who was here, and God bless him. I think we
couldn't survive. Y'all are all getting an award that stayed this long, an honorary law degree, as someone suggested earlier. While you're standing there, can you handle House Bill 635?
Yes, sir. Don't scare me. I'm thinking you're assigning me some new ones.
So let's make sure we have the right LC as we close out. One more bill after this. LC 413147S. This is a committee substitute. The floor is yours.
Thank you, sir. Hold on a second. Let me change gears here.
A little different topic.
Yes, sir, indeed. So this bill is sort of a combined bill that combines provisions sought by the Council of Superior Court judges with a number of the initiatives adopted by the COVID-19 task force of the Judicial Council. We all heard Chief Justice Melton last week, and a number of the initiatives that he referred to in his State of the Judiciary speech are actually included in this bill. If I can find my notes, pardon me, Mr. Chairman. The initial section of the bill basically deals with what I call remote acts. It allows judges to sign orders when they are outside certain geographic limits. Currently, the law requires they be within state. They can sign them remotely, but they have to be within the boundaries of the state. And that section would simply expand that to allow them to sign anywhere. So it's sort of aimed at judicial efficiency so that we don't hold cases up or prevent them from being disposed of because of that. And it just deals with various classes of courts as well as different processes like arrest warrants and search warrants, courts of inquiry, and that sort of thing. So I think that's fairly simple and but yet needed, I think, to promote judicial efficiency. That is not necessarily the result of the pandemic, but it does have implications in the pandemic and will I think, be useful in allowing us to clear the backlog as well. Section 2 concerns moving court to alternative locations. And that, well, I say Section 2, it's Part 2. Section 2.1 on page 7 of the proposed substitute. And it's a little deceptive because all of the language of 15.618 is underlined, which would make you think it's a brand new code section, but it actually is not. There is an existing code section on alternative locations, but it contains a section or a paragraph that is a population bill, so we have to repeal and replace. And the main change here is just allowing that if an alternative location is chosen, under current law, the governing body has to have a lease or has to own it. And this would just provide that the governing body either has to own it or have a contractual relationship for the use. Because some facilities that we've used, I think, during the last year, don't always like to sign a lease. They'll give you a license agreement or enter into some other contract to allow you to use the facility, but you can't do a lease there. So it still provides some limitation, excuse me, Mr. Chairman, but does allow for the moving of court under the circumstances set out in the statute. And because of the removal of that paragraph that had the Population Act, the statute has been reworked slightly, but it's substantively the same, with a few exceptions that were largely occurred during House Judy. We've added a requirement that the court and the governing authority consider traveling convenience for transportation, and also when you move it, it has to be within the county that you're located in or an adjoining county. And then finally, Part 4 contains what were actually House Bill 555 and 556. These are also task force recommended provisions. One of them allows the defendant in a criminal case to elect to proceed with a bench trial rather than a jury trial. And as I don't do a lot of criminal work, but my understanding is now the prosecutor has to consent for that to happen. Under this bill, the prosecutor would not have to consent. The court would consider any objection that the prosecutor offers, but
is that directly related to the bill that I carried that deals with waiver of speedy trial demands, but gives something for the defendant that may want to trial faster, additional option to have a bench trial instead?
Yes,
okay.
Yes, sir, that's exactly right. And that provision is sunsetted. It sunsets June 30, 2022. Again, the idea is to try to keep cases moving and to deal with this tidal wave of a backlog that's coming at us right now. And there are exceptions in there. It doesn't apply to every case. There are exceptions if it's a serious violent felony, which are the 7 deadly sins, murder, armed robbery, rape, kidnapping, and so forth, then the statute does not apply. Similarly, there is or perhaps conversely, there is a provision that allows prosecutors to initiate certain charges by accusation rather than by indictment and a grand jury presentment. There currently is a statute that allows that. My understanding is you have a constitutional right to go before a grand jury on a murder case, you have a statutory right in other felonies, except certain enumerated felonies in a code section, which includes things like theft by taking and escape and airing an auto. So we already have provision in the law where prosecutors have the option of initiating a case by accusation. These amendments would expand that to other felonies except for the 7 deadly sins, and would allow prosecutors just to initiate those cases by accusation where the defendant had either waived commitment or had been committed or was out on bond. So again, the idea is to try to get these cases moving and proceeding to a disposition on the merits rather than on some kind of technicality. And that is also sunsetted as well.
So in everything we're doing on these recommendations from the Judicial Council, we're kind of giving something for everybody there to hopefully balance the issues. When you're looking at waiving statutory speedy trial, you're looking at the idea of trying to move forward still where you can't get a grand jury together with charges, and also, of course, looking at the option of a bench trial versus jury trial. Things are all going to be sunsetted in our code, all 3 items, 2 items you have here and 1 in the separate bill the House already took up. Is that correct?
Could not have said it better, Mr. Chairman. I appreciate it.
And all right, we have one person signed. Any questions for the author? We have one person signed up to speak on the bill. We have Judge Brasher from Fulton County Superior Court with us again.
Excuse me, Judge, you move faster than I do.
No, sir, no worries.
Thank you, sir.
Absolutely. Good afternoon, Mr. Chairman, members of the committee. Thank you for allowing me to speak. I come before you to speak in favor of House Bill 635, both on behalf of the Council of Superior Court judges as well as the Judicial Council. As Mr. Chairman, you noted, these bills come from both the Judicial Council there and the Governor's Task Force, as well as from the Council of Superior Court judges. We're asking that you entertain favorable consideration of this bill so that we can operate as efficiently as possible as we emerge from the darkness of COVID. Our primary goal is to free up as much capacity as we can to handle the things that must be handled. And so we're mindful of that in all the various ways that we're approaching this, because, you know, for instance, we picked a jury this week in Fulton County, the first criminal jury we've picked in a year. We picked it in the assembly hall for the county commissioners because that's the only space we had that was big enough. Now, obviously, that's not a sustainable model to try hundreds of felony cases over the next 3 years, but it's a place to start. And so, again, what we're trying to do is use every avenue we can to use the resources we have as efficiently as possible. Specifically as it relates to the remote jurisdiction, you know, these are tools that the business community has at their hands that are used and have been used now for over a year. We just want to be able to handle these things and keep cases moving wherever we are, whether it's at the bar meeting in June in South Carolina or if it's somewhere else. Likewise, as far as the alternate locations, we may be able to stand up additional courtrooms in Fulton County and other counties as well, and we may need space. And if we have to do that, we're going to do it in a way that isn't going to inconvenience jurors. Rather, it's going to make our process more efficient so that we can use the secure space of the courthouse for the defendants who are in custody and be able to use other spaces in a secure and safe way. Again, we want to get back to the business of trying cases and moving cases through the criminal justice system safely, effectively, fairly, and under the Constitution. And so we ask for these tools to be able to do that.
Thank you, Judge Brasher. Any questions for him? All right, there's no one else to speak on the bill. What's the pleasure of the committee? Move to pass by Senator Jones by committee substitute LC 413147S. Do we have a second? Second by Senator Parent. Any discussion? All those in favor of the motion, please raise your hand. Carries unanimously. Hang in there, Kay.
Mr. Chairman, thank y'all so much.
And who's going to be carrying the bill in the Senate?
I believe
Natalie can't carry bills.
Right, yeah.
Pointing to her.
I believe someone we all know well and
okay.
Who's going to be
all right, we'll see. All right, thank you. Last bill on the agenda, Representative Scoggins, you've been so patient all day. You haven't texted me once asking when you're coming up. I guess it worked to your disadvantage.
Well, being last at lunchtime has its advantages. I hope it'll go fast. So.
Everybody's hangry, and
keep it on.
This could go really good or really bad.
Okay.
We'll see where it goes.
This is House Bill 464.
What's your LC number you're working on?
LC number is 412891.
All right.
This bill is on behalf of the probate judges of the state of Georgia, and we had help from the state bar on drafting this bill. This bill only allows the probate judge to transfer a temporary guardianship of a minor child from the probate court to the juvenile court for the benefit of the minor child if the judge doesn't feel it's in the best interest to grant the order. The way the law is set up now, or the statute is set up now, the judge doesn't have any authority to transfer the case to juvenile court. The law says you shall grant the order with consent of both parents. So this allows this case to be transferred to juvenile court, because juvenile court has the arm of DFACS that can do home studies and find out what the best interest of the child is.
And so it's a balancing act, because currently parents can just consent and it has to be granted a current law, but this will give a judge discretion to actually have this sent to the juvenile court for determination instead. Is that fair to say?
Absolutely.
Any questions for the author? There's no one that signed up to be heard on the bill. What's the pleasure of the committee? A motion to pass by Senator Hatchett. We have a second. Second by Senator Kirkpatrick. Any discussion? All those in favor of the motion, please raise your hand. It carries unanimously. Before you go, don't go yet. Who's going to carry the bill in the Senate?
I've spoken to Senator Hatchett about carrying it, and we haven't worked out the fine parts of our contract yet, but we're working on it.
Senator Hatchett, before you leave, thank you. Committee, there's not a lot of us left, but we should recognize the staff that has supported us this session and got us through all this today without any issues. And so Beth Vaughn with Senate Research, you guys already knew before, who's done a lot of work this session. And the new people with me, Natalie Murphy, that's kept all this stuff straight. Sky Park, who's worked with the committee, is one of our legal aides as well. And Brad Scrober, who's also worked with us this year with the committee. And of course, Patrick Bilecki working with me directly as well. And we were all new at this together, and I think it's gone pretty smoothly. So I appreciate the work y'all have done for the most part. Yeah, appreciate the work y'all have done. I hope y'all recognize them in the committee. Thank you. With that, we are adjourned.